writ petition, Lordship, on Monday for motion.
What?
For motion, Lordship.
When?
On Monday, Lordship, 27. Online, Lordship.
Lord, with regard to item number 71, my lord, an affidavit is in file yesterday, my lord. That is not been tagged with, my lord. That may kindly be called for. Moreover, one more thing, my lord. Since a direction is made by you to file yesterday, we could not serve the copy and
It's
respond
okay,
number
no,
4, my lord.
you have filed it, no?
Yes, yes, yes.
My lordship, supplementary list, item number 69. My lordship, I have come from Bangalore to appear in this matter, not knowing the serial number, item number, my lord. So I pray my lords and I request my lords to post the matter at 2 p.m. my lords.
Okay.
Much obliged.
Item number 25 and 26. I pray for some accommodation for the day. 25 and 26. I've taken the consent of the other side, man. Only for the day, man.
What is the matter about?
My lord, here it was cancelled, man. Tender was, work order was cancelled, man, of the writ petition.
Affidavit,
Yes, it's there. It's there.
file reply?
Reply, my lord, probably, yes, reply also filed in the first item, madam.
Hmm?
In the first item, reply filed. Second item is regarding non-payment, then there we have filed the affidavit also.
And they have not filed reply.
No, man.
Okay. We take it up sometime later in the month of September for final disposal.
Lordship. Because, my lord, the work, yes, man.
Will they stay?
There is a stay. Because of the water logging, my lord, I could not grab the file and all. That's why I'm praying, my lord, otherwise.
A is in item 23
23. No, 25, madam.
or 25.
Hmm. 25,
Okay,
25.
we have it on some other day, then
Yes, madam. Any day
as there
convenient.
is a stay.
Well.
Mr. B. Gogoi, the learned counsel, council, standing counsel of the PWD submits that on account of water logging, he could not trace out the file for which some accommodation may be granted, taking into account the above, these matters again on 12th of August.
That's.
There is an interim order.
Yes, yes, there is the intent.
The interim order passed in WPC number 4948 of 2023, Silo, huh? And extended till the next.
May it please your lordship, I am praying for listing of a writ petition for withdrawal, my lord, on Monday. Obliged.
May it please your lordship. In item number 13, we have filed an IA for implement, lordship, but the IA has not been listed. So the IA may be taken up today along with item number 13, lordship.
Has been brought to the notice of this court with an interlocutory application thereby to implead. Whom?
Respondent number 2 and 3, lordship.
It's somebody, na? Whom do you want to implead?
Lordship. The Deputy Commissioner Baksa, lordship.
For impleading the present incumbent Deputy Commissioner Baksa.
And the additional Deputy Commissioner come Nazarat office, Nazarat branch, Baksa, lordship.
With an incumbents. Implead with an incumbents. While holding the post of the Deputy Commissioner Baksa as well as the additional Deputy Commissioner, District Commissioner Baksa. Considering the above, matter stands adjourned to be listed on 17th of August 2026, along with the said interlocutory application file.
Much obliged,
May it
lordship.
please your lordship. Item number 22, lordship. Other side is also present petitioner side. Lordship, some inquiry has been directed to conduct regarding a sale deed of 1952, lordship. 1952 sale deed, they have challenged, the petitioner's prayer is regarding a sale deed in connection with 1952, lordship. And inquiry was ongoing and further status was not received. So petitioner side is present, lordship, some more time is required, lordship. So I'm
Who
praying,
is asking for time, the petitioner or the respondent?
I'm praying for with the consent of the petitioner side, lordship.
Mr. N. Chaudhary, the learned standing counsel of the BTC, admits that some more time may be granted to the petitioner, respondents for providing the instructions as regards the inquiry.
Yes, Lordship.
Taking into account the above, list this matter on 16th of September 2026.
Lordship,
State, the BTC Council shall produce the inquiry report.
Lordship, I have another prayer, Lordship, regarding item number 54, admission matter, Lordship. We have received instruction yesterday, Lordship, so some time may be given to file affidavit. Item number 54.
Is there a stay?
Yes, Lordship, there is interim order. There is interim order, Lordship.
When was the notice issued?
Lordship. 26 to 25.
Ms. N. Chaudhary, the Learned Standing Council of the BTC seeks for an accommodation to file the affidavit in opposition.
Yes, Lordship.
This matter again on 25th of September 2026. In the meantime, the affidavit in opposition be filed. Taking into account that notice was issued on 26/2/2026 and there was an interim order and there is no urgency shown on behalf of the respondents to file the affidavit in opposition. This court observes and directs that the interim order passed on 26/2/2026 shall continue until further orders.
May it please your lordships.
Obliged, Lordship.
Also, I'm filing two IAs, lordships, in respect of a stay vacating application. These are stay vacating application. The main matter has been listed on Monday, lordships. So, lordship, it may come up along with the main matter.
You have filed interlocutory.
Two IAs we have filed, my lord, stay vacating
Matters
application,
be listed
along with these IAs.
on 27th.
Lordships, that's a mention. I'm so glad.
I may appeal, Lordship. I beg to mention for listing one motion matter.
Then today,
No, my lord, Monday.
May I please, Lordship, item number 34, Lordship. In this matter, one IA was filed, Lordship, which is not part of the record. Record may be called for
you are appearing for
Ali, Mr. Ali.
for the petitioner.
Petition.
Is there a stay order?
Yes, Lordship.
We'll see when the matter reaches.
Yes, Your Lordship. Lordship, I beg to mention for item 29 for adjournment.
Why?
My senior counsel is out of station.
There's an interim order
No.
at the request of the Learned Counsel for the petitioner, the matter stands adjourned.
After 1 week, Lordship.
Will be listed on 5th of October 2026.
May I please your lordship, my lord? Here, my lord, instant case, my lord. This honorable court has directed to file an additional affidavit. I also filed the additional affidavit. The order dated, my lord, is not complied with, my lord. Your lordship kindly come up to the operative part, my lord, page 42, page 33, my lord.
Yes.
Your lordship got it? From the facts and circumstances obtaining above, it is evidently established that the respondent authority has arbitrarily denied the petitioner real and meaningful effective opportunity of being heard, being visited, drastic penalty of holiday listing for a period of 1 year by the impugn order dated 22/1/2000. To take the action of holiday listing, the respondent IOCL have referred the holiday listing guideline dated 19/1/2000.
Understood. The direction, the impugn order has been set aside.
Stayed aside, my lord.
Then
Still today, I was put in holiday list, my lord.
how?
Yes, my lord. They put my lord. I saw your lordship, my lord. Lordship, kindly come to the my lord additional affidavit filed by me, my lord. 137, my lord.
Yes.
29/6/2026. Parcels block, posting block, yes, my lord. I was still in holiday list, my lord. I could not participate in the tender process and other, my lord. I stated in my lord, petition also, my lord. Era 6, my lord.
No, no. Your holiday list has been removed.
Not remove, my lord.
No, no. The court have already set aside and quashed.
Yes, my lord.
So if you still are continued out there, it is a separate cause of action. It has to by way of a writ petition
My lord,
for removing it.
My lord, may I submit, my lord?
No, no, no. This is not a case.
My lord, may I submit, my lord? Impugned order has been set aside, my lord.
Understood. It has been set aside.
Yes, my lord.
Now, if they still continue, it doesn't remain.
Yes, my lord.
So therefore, if now also you are there, continued, have you represented to them, kindly remove this?
Yes, my lord.
When?
Yes, my lord. Lordship, kindly come to the, my lord. My lord, representation. Para 6, page
Para?
46. My representative, para 6, page 46.
Page?
46 of the additional affidavit. May I read, my lord?
Yes.
That despite due to receipt of the aforesaid email dated 17/5, which is formally served on so and so, passed by the Honorable Court, Gauhati, set aside the impugned order dated 22/1/2020, by which the edition was put holiday list, and a recovery of proceedings 7,80,400 even 91 only. The undersigned further state that despite of intimation, the aforesaid order 6/5 to the passed by the Honorable Court, you still put the petitioner farm addition in holiday list. Till today, you did not release the amount so and so, so and so. The aforesaid action on your part, your officers willfully, deliberately disobeyed the judgment order passed by the Honorable Gauhati High Court, set aside and quashed. At 22/1, the edition was put holiday and recovery proceedings so and so, so and so, because you still put the petitioner farm edition in holiday list. Still today, you did not release the amount so and so, so and so. The continued
And
defense.
this particular page which we have referred to, that page
Yes, 46.
137, what is the date of this document?
It was, my lord, received by them, my lord. That is the seal, my lord.
No, no, what is the date of this document?
13 July 2025, my lord.
Where?
Annexa 1, page 44.
No,
my-
page 137. What is the date of the document?
137.
Yes.
137, date of the, my lord, top 26,
29/1/2000
2026.
to 21/1/2000.
29/6/2026.
This is prior to that. This document came into existence prior to this, prior to the passing of the order.
No, my lord.
Yes.
Well, after passing of the order, this is
How do you know?
29/6.
Show me the date of the document.
29/6/2026.
Where are you getting
It's not-
29/6?
No, no, 29/6 come there.
Where?
This is 29/6, my lord.
That is 29/1/2026.
This is one of the document, my lord.
That is the document which you are referring to. No, I'm not going to look any. You have been granted an opportunity to file an additional affidavit. You have not filed an additional affidavit bringing on record. The order was passed by the learned coordinate bench on 6/5/2026.
खाली पहले देना 29/6.
And you have given it on 13th of July 2026.
This
No,
was 24.
no, Mr. Counsel.
My lord,
First of all, you have filed
My
this.
lord.
No, absolutely no. You have filed this contempt application, and your document which you have to refer to now is received on 13th of July 2026, Annexure 1. Why should we entertain this type of contempt application?
my lord, 29/6, my lord.
Absolutely no.
এখন document একটু কোথায়?
It's 29. No, further to that. You filed the contempt application even before submitting the representation.
My lord, before, earlier I sent the order on email, my lord.
In that order, there is no mention that kindly remove it from a particular holiday list. Your holiday listing was set aside.
এখন 29(6) খন দিয়া নাই।
You submit the document on Annexure 1 is received on 13/7/2026 and you file this in the month of June 2026.
Yes, my lord.
Then we dismiss your petition.
My lord, I may be allowed to withdraw this petition, my lord.
You
Lord,
cannot withdraw. We dismiss it.
My lord,
Contempt you cannot withdraw.
My
Can you
lord.
withdraw contempt?
my lord, just a minute.
No, nothing doing. Dismiss with cost.
This is the 29(6), my lord.
Necessarily filing this time. No, absolutely no. First of all, when you are writing, you have submitted the representation on 13/7 prior to the filing of the, after the filing of the contempt petition. How is it possible?
That is why we filed the additional affidavit, my
So,
lord.
therefore, can you maintain a contempt petition?
My lord, what you have stated, my lord, that is, my lord, holiday from 2009/1/2026 to
Therefore,
21.
this document
Lordship.
existed. No, this document existed prior to that. When was this document issued?
Lordship, kindly
No,
come.
I have seen that document. My question is till 2027. It is mentioned. My question is, when was this document issued?
Yes, ma'am.
When?
Document are issued long back, my lord, because 29/1 to
When? No, I will not. We dismiss with cost, unnecessarily filing all this.
my lord, kindly, my lord,
And you
because,
can
my lord,
take the liberty to file a writ petition if you wish.
my lord, my humble submission before your lordship is that, my lord.
Therefore,
Yes, my lord. Your lordship, my lord, I have got one document. Let kindly look at it.
You
Hello.
submitted your representation subsequently.
Subsequently, my lord.
Then.
Your lordship, kindly.
Heard Mr. NNB.
Lordship, kindly look
No,
at it.
nothing. Heard Mr. NNB Chaudhary, the learned counsel, appearing on behalf of learned senior counsel, assisted by, what is your name? So and so. Appearing on behalf of the petitioners in the present batch of 3 contempt
Hello.
applications.
Allow to take this, my lord, document, my lord.
The present contempt applications have been filed alleging willful and deliberate violation to the judgment and order dated 6/5/2026, passed in 3 writ petitions being WPC number 800/2026, WPC number 804/2026, and WPC number 805/2026. The relevant part of the said judgment and order passed by the learned coordinate bench is at paragraph number 42. And 43. 42 and 43, which are reproduced here in under. Page 33 and 34. From a perusal of the above quoted paragraphs of the judgment and order dated 6/5/2026, passed in the 3 writ petitions, it would be seen that the learned coordinate bench of this court has set aside the impugn orders dated 22/1/2026. Set aside and quashed dated 22/1/2026. It is the case of the petitioner. It is relevant to mention out here that there is no specific directions in the said judgment and order that the impugn orders that the orders by which the petitioners in the 3 writ petition were put in the holiday list, their names should be removed. The learned senior counsel appearing on behalf of the petitioner submits that in spite of the orders dated 22/1/2026 having been set aside, the petitioner's name still features in a list so prepared. And in that regard, had referred to page 137, which is a part of the additional affidavit so filed on the basis of an order passed by the Learned Coordinate Bench dated 24/6/2026. The said document, however, do not mention the date on which date of the do not mention the said document at page 137. Do not mention as to when the said document came into existence. This court further takes note of that the petitioner had submitted a representation which was received or dated 25, submitted a representation which was only received on 13/7/2026, much after the filing of the present contempt applications. Under such circumstances, in the present manner, the contempt proceedings cannot be proceeded with, and no notice can be issued in the present proceedings, as apparently this court do not find that there is a willful or a deliberate violation to the judgment on order dated 6/5/2026 passed in WPC number so and so, so and so, so and so. Accordingly, this court dismisses the present contempt applications. Before parting with the record, this court finds it very pertinent to observe that when the orders by which the petitioners herein were put into the holiday list dated 22/1/2026 were set aside and quashed by the Learned Coordinate Bench in the judgment and order dated 6/5/2026 in WPC number so and so, so and so, so and so. The petitioners cannot, the said order had become non-est. And under such circumstances, on the basis of those orders, the respondent authorities, that is the Indian Oil Corporation, cannot continue, cannot take note of those orders, the orders dated 22/1/2026, whereby the petitioners were put into the holiday list. If the petitioner is aggrieved at such action, it is a subsequent cause of action, and the petitioners will be liberty to file separate writ petition if so advised. I gave you more than what you want.
That's all less.
Please. So the order from which the contempt petition arises is at page number, my lord, 13. It starts at 13. And the relevant portion, my lord, will find at page number 15, my lord.
What?
Relevant portion, my lord. Paragraph 5, my lord.
Pay to the petitioner the balance account in 6 weeks.
Admitted outstanding liability, my lord, 3,82,000, my lord.
Who filed an appeal?
My lord, this petitioner filed an appeal, and then appeal was subsequently withdrawn with the liberty to approach the competent civil court, my lord, regarding that disputed liability. Insofar the admitted liability is concerned, my lord, this is
There is nothing, no liberty was gone.
kindly see page 17, my lord. Page 17, the last paragraph, my lord. In view of the above, the writ appeal stands dismissed as withdrawn with liberty. So the petitioner himself filed. And now, my lord, he only wants the, my lord, the admitted liability, my lord.
Fantastic.
That's
Admitted liability, when did you ask for?
It was asked, my lord, on my lord.
4/7/2026. 6/6 is over?
My lord, in that case, my lord, six.
Dismiss.
uh,
Dismiss.
uh,
Dismiss. You have, it's premature.
If you,
Bravo.
my lord, in that,
Absolutely no. Your urgency cannot happen like this. There was a specific direction that the payment would be made within 6 weeks from the date of
Yes.
certified copy. The certified copy you gave on 4/6. Today 6/6 is not there. Why should
my
we?
lord, because my lord, there was a writ appeal pending,
So what?
writ-
That cannot be. You only submitted on 4/6.
for, after the writ appeal, the representation was submitted.
So is 6 weeks over? My simple question.
The simple answer is, my lord, it's no. Therefore, my lord, may just point out one thing,
Mr.
because
Counsel, these type of litigations, I think, don't worry. Petitioner, no cost. Cost upon the counsel for the petitioner for advising, giving such wrong advice. For not waiting for 6 weeks and then filing it.
because, my lord, the problem is
Heard
1 year,
Mr.
if it
No,
gets passed,
nothing doing.
limitation will come, my
You
lord.
want to withdraw?
I want to withdraw, my lord. With
Mr.
liberty.
A.K. Borua, the learned counsel appearing on behalf of the petitioner submits that taking into account that the period of 6 weeks, as mentioned in the order dated
13/6/2025.
13/6/2025 passed in WPC number 982/2023 is not over from the date of submission of the certified copy, which was submitted only on 4/7/2026. The petitioner would not like to press the instant writ petition. He, however, submits that in the circumstance, the order dated
13/6/2025.
13/6/2025 passed in WPC number 982/2023 continues if not complied with, the petitioner may be granted the liberty to again approach this court. Taking into account the above, the contempt application stands dismissed on withdrawal. However, before parting with the record, this court, however, observes that in the circumstance after a period of after the lapse of 6 weeks, if the order dated so and so passed in so and so remains uncomplied with, the petitioner would be at liberty to again approach this court. I hope you don't come after immediately 6 weeks. Come after 6 months because of the fact that you gave this after 2 years.
If
If I get again, I remember.
deeply.
What it is,
Lordship, may I please, your Lordship, I'll be fair, the writ petition will be misconceived to the effect, they have a effectious remedy,
raise the plea with regard to the maintainability of the writ petition.
because with regard to the ESI, there's some assessment, they have to go, the petitioner ought to have gone to the, Lordship, only prayer is they have also filed in 45AA application for the assessment, which was filed in 15th of May, Annexure 2. If they consider that Annexure 2 at
Why
page,
should we entertain these type
because
of petitions?
otherwise they would be counting the limitation from the date of the assessment order.
Don't worry, I give you the limitation. He has initiated the proceeding. He is making that submission on maintainability. And if he is making that submission, then obviously I will relegate it. Once I relegate it, have to give you the limitation. Otherwise, it does not become efficacious remedy. Isn't it, Mr. Smith? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers.
1 to 4, my lord.
Huh?
1 to 4.
1 to 4. The present proceedings have been filed challenging the order dated. What is the assessment order?
No, see, assessment order copy was not given. We only have the prohibitory order to the bank accounts, which was supplied to us by the HDFC Bank.
Where?
Annexure 1.
Is it the prohibitory order?
Yes, Lordship.
You have the assessment order?
On assessment order, no, my lord. I do not
Do
have.
one thing, we have it on. Get the assessment order from somebody. Ask them to give you one WhatsApp, give it to him.
I'll give
We'll
it
take
in.
it up at 2.
My lord.
Finish it off so that we can give him the assessment order, then he can challenge it.
My lord.
Okay.
Yes.
Then we can say that here.
My lord.
Highly obliged, Lordship.
May please your lordship. Lordship may kindly take up supplementary item 75 first. Same petitioner, same counsel.
Why?
Because this matter become influx to us 75.
Oh, 75 only. There's so many matters. 75.
Lordship.
75, I am appealing for Apollo 4.
What, yes, what is your case?
Lordship,
You are the counsel for both the parties?
Lordship,
Okay. What is your case?
Lordship in item 75,
Start with 6 only.
Lordship, item 6.
What is your case?
Lordship in item 6, your Lordship, my technical tender has been rejected by the IWT.
Why?
I have not submitted boat registration certificate, your Lordship.
Work?
Boat registration certificate,
Oh.
page 27.
Page 27.
Lordship.
This is your registration.
Lordship,
This is your registration.
my registration is page 30.
Yes. Vote. No, you have not given this document.
Not given this. Though I have submitted the fitness certificate, or is called the certificate of survey at page 27. In this certificate of survey,
Kindly come to page 18, serial number 8. There's a requirement of you to submit the boat registration certificate.
Lordship,
Why didn't you submit?
Lordship, kindly come.
Because I don't look like a tendering authority.
Lordship,
Is that?
Lordship, please come to the NIT.
So therefore, if it was a term of the NIT, you have not submitted that document.
This has been not stated in the rule yet, sir. Rule
Forget about that. In the tender, it is mentioned.
Lordship, please come page 14, NIT.
What is this document?
NIT.
NIT, what does it say?
Close 10 year, Lordship.
Submit the up-to-date
Lordship.
boat
This is a boat registration certificate and valid
certificate of survey of his animals. In case of joint owner, one owner can submit the tender for the year. Then
Then please come to page, next page, close 22 year, Lordship. May I read? Clause 22(1). The lessee must operate the existing govt vessels boats in the ferry service by his own arrangement, such as expenditure of fuel, crew, and other maintenance of the vessels and guards to be honors of the lessee under supervision of the IWT officers. The lessee has to operate govt vessel provided by the executive engineer IWT Assam. In absence of departmental or govt vessel, the successful bidder must operate vessel by his own arrangement. That means, Lordship, this clause 10, the condition 10 may be come after, at the time of settlement, your Lordship. And this is not mandatory. This is not mandatory. This is subsidiary, because this has not been flow from the rule, your Lordship. And this is contradicted 10 and 22.
now tell me why you are filing the second writ petition.
Second writ petition is that, your Lordship, I have been operating this.
What is the first writ petition now? Tell me. 3713.
Yes. Supplementary 75.
Second, your Lordship, only the issue is that a temporary arrangement was made in my favor.
So now is your writ petition 75 has become infructuous.
Yes, my lord.
Now, as the respondent number 4 has been permanently granted.
From
No,
1/8,
not
from
granted.
1/8, from 1st of August. Now he is running because earlier he was.
I am
temporary
running, your
settled.
lordship, on
Till
From
31st.
1st of
31st
August, he is
He is,
running.
yes,
Order has not been provided. I have
Not
no.
necessary to
then
provide you.
I can give.
No, first of all, this type of writ petition is also not done. We dismiss this type of petition. What right do you have to continue? This is not a job, a temporary by another temporary.
Lordship,
My question is, as of now, unless you overcome the second writ petition,
Yes.
the hurdle in the second writ petition, you cannot be allowed to continue.
lordship,
And as you are, by way of an interim order, you got the final relief.
Yes.
lordship, no,
Yes.
only the, in 75, only the issue is that till 31st,
You are running.
running.
So they are going to give it to you to
Till
run.
31st, I am
Yes,
running.
he is
The
running.
matter becomes
Lordship.
infructuous.
Infructuous.
On 31st, Macam become
It will be
infructuous.
given to him.
And then from 1st of August, it has been settled,
To
given
him.
to him.
Okay. So here,
Now, this,
wait, let us close verse
Yes,
75.
75.
Heard Mr. P. Rahman, the learned counsel, appearing on behalf of the petitioner. Ms. M. D. Bora, the learned counsel, who appears on behalf of the IWT
Lordship, for 1, 2, and 3.
1, 2, and 3. And so appears on behalf of the respondent number 4. The present writ petition was filed by the petitioner, being aggrieved by the actions on the behalf of the respondent authorities, that the respondent number 4 was permitted to run during the temporary period, temporary settlement so granted to the petitioner, which was effective till 31/7/2026. This court duly takes note of that when the writ petition was filed on the learned coordinate bench by an order dated 17/7/2026, while issuing notice, suspended the order dated 15/7/2026, whereby the private respondent number 4 was permitted to run the ferry service with effect from 16/7/2026 till 31/7/2026.
Lordship.
The said order dated 15/7/2026 was accordingly suspended by the order dated 17/7/2026 by the learned coordinate bench. Ms. M. Deborah, the learned counsel, appearing on behalf of the respondent numbers 1, 2, and 3, submitted that in view of the order which has been passed by this court, dated 17/7/2023, 17/7/2026, the respondent number 1, 2, and 3 is not going to disturb the petitioner's temporary settlement, which was effective till 31/7/2026, and thereupon, with effect from 1/8/2026, the respondent number 4, who has been chosen to be the
Highest valid bidder.
who have been chosen to be the technically competent and the highest bidder pursuant to the notice inviting tender,
Lordship.
would be running the ferry service. In that regard, the learned counsel has placed before this court a communication dated an office order dated 17/7/2026, which is kept on record and marked with the letter X.
Deeply obliged, Lordship.
Taking into account the said aspect, as the petitioner's temporary settlement granted up to 31/7/2026 is protected, nothing further remains in the instant proceedings, for which the instant writ petition stands closed. It is observed, before parting with the record, this court observes that the submissions so made by the learned counsel, standing counsel for the respondent numbers 1, 2, and 3, that the petitioner would not be disturbed till 31/7/2026, coupled with the office order dated 17/7/2026, shall be taken as an undertaking given by the respondent numbers 1, 2, and 3, that the petitioner would not be disturbed in the temporary settlement for the period up to 31/7/2026. It is also made clear that post 31/7/2026, the petitioner shall have no right to continue with the ferry service unless there is a separate order.
Deeply obliged, my lord.
Now come to the main petition.
Yes.
You have been held to be technically non-responsive on account of the boat registration
Registration
certificate
certificate.
not being given.
Not been given.
Very well. Now what is this?
So I have received instruction in this matter.
Lordship, in the NIT, there is a waiver clause also.
Waiver is them. Why can this court direct waive?
No, no, no. I am not asking your Lordship for
In fact,
director to
lordship,
waive.
in this
So
petition,
what should I do? Should I dismiss
Only
it?
issue is
There are
that-
two options, Mr. Rama. Either I can dismiss it right away. You get kind judges in the division bench maybe and look into it. Or I can issue notice for your satisfaction to be dismissed on a subsequent day. Which one?
Lordship, only one submission here, Lordship.
You don't get a stay.
yes.
No
Lordship,
stay.
at present, I am not praying for stay, your Lordship.
Then your matter becomes
Since I am-
infructuous.
I have not challenged this order, your Lordship. Ladies,
No, no, forget
order has
about
been-
that. Order is the which order?
That only settlement has been given.
This is a permanent settlement.
Oh, no, that's a different thing.
Lordship.
That is a different
My
thing.
only
Now the settlement has been given.
given, Lordship, from 1st of August, from 1st of August.
2029.
My
That is not a settlement.
The order is yet to be issued, but this and is under process, my lord.
main
I have
order
been
yet to
informed.
be issued. My,
It has been given, the responsible for has been given, we become.
That
the
order need
distributor.
not be challenged. You
Yes.
need to challenge the settlement order.
Settlement order.
Lordship,
It will be.
my only submission,
Into a
only
few
submission
minutes.
here is that clause 10 and 22 may be taking consideration, Lordship, and yes,
Mr. Counsel, I would have. You see, you are saying it to be directory. First of all, concept of directory or mandatory has loses significance in view of the recent judgments which have been passed in the case of those coal mines and all, coal fields. What coal field? One is the coal field, the other is the F1s and all. So now it is absolutely within the purview of these authorities as to whether it is mandatory or directory. But one thing makes it further clear that it is mandatory, because not only it is mentioned at clause 10, but also in the tender document, tender application, there is a categorical mention.
Yes.
How do you take care of that? Problem lies there, Mr. Counsel. You have tried your best, but I don't think, see,
In fact, my lord is well aware. There are so many incident, my lord, because of the lordship
Lordship,
past.
Lordship, yes.
students is there.
Yes.
Yes.
In
But nowadays, you
Free
see,
complaints
in
from-
Milan Hawk, your Lordship,
the council, another thing very relevant out there. Your case is that you are to run the government vessels. And as such, the boat registration certificate is not required. Your submission, that is why you are bringing in 22. But the fact remains that if the government vessels are not available, your vessel has to be.
has to be,
working.
has to be applied. Has to be applied.
And there makes it, nowadays you see in view of the inland vessel rules.
Yes,
Act,
yes, yes, 1950.
which is the central act now.
My lord.
Now it has become mandatory to do read all
Yes.
these things, Mr. Counsel.
Lordship, I,
Anyways, what do you want now?
in Milan,
I've given you two options. Today I don't have the luxury of having. a
notice may be
good
issued.
smile and a case taking into account that I've been told that I have 75 matters.
Notice may be issued, your Lordship, in this matter.
what?
And
Then
I'll be allowed to,
Complete the private respondent in matter. If not, it will go.
I will implement the respondent number 4, private respondent. There it is not
You
implemented.
do one thing,
Lordship.
you withdraw it
Lordship.
without prejudice to your cause of action here.
Lordship.
And taking into account that document,
Lordship.
that you are going to give it to him, the moment a settlement is granted to again challenge it,
Lordship.
then it will be
Lordship.
cumbersome. Otherwise, for you to come again, another repetition has to be filed.
Lordship.
Yes.
So keeping this thing alive
Lordship. Will liberty.
with liberty in view of that document,
Lordship.
I think better off.
Lordship.
Hello. Heard Mr. P. Rahman, the learned counsel, if you. Yeah, I got to. The learned counsel appearing on behalf of the petitioner submits that a present writ petition has been filed challenging the action on the part of the respondent authorities in holding the petitioner's bid to be technically non-responsive on account of non-submission or on account of the non-compliance to clause 10 of the notice inviting tender. The learned counsel appearing on behalf of the petitioner submits that the clause 10 cannot be treated to be a mandatory condition and mandatory condition in view of clause 22 of the notice inviting tender, wherein it is mentioned that the lease is to be granted in respect to running of the government vessel, and it is only when the government vessel is not available the bidder's own vessel is to be used. The learned counsel further submitted that though the respondents have a discretion to waive, but when a discretion has not been exercised in the manner in which it should be, the action comes within the ambit of malice in law. On the other hand, Ms. M. Deborah, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 submits that the term mentioned in clause 10 is a mandatory term in as much as in view of the Inland
Vessel
Act
Act,
dated,
1921.
no, recent one.
Lordship, I will give the year. ma'am.
That is the name of that act now,
Yes, sir.
recent act. I have taken into consideration in one matter.
Yes, my lord.
In view of the Inland Act, so and so.
1930.
On account of the various accidents, it is required that the said both registration certificate ought to be placed. In addition to that, the learned counsel further submits that in the meantime, after the technical evaluation being carried out, the financial evaluation was carried out amongst the eligible technically qualified bidders. And one, what is your name?
Mohiruddin.
Mohiruddin. One Mohiruddin, M-O-H-U-D-D-I-N, have been chosen as the highest bidder.
Lordship. Has valid bidder.
Yes, valid
Valid
bidder.
bidder.
And as such, the department is in the process of granting the settlement in favor of the said so and so. The learned counsel appearing on behalf of the petitioner submits that in view of the said submission so made and coupled with the communication which was placed before this court in WPC number 3713/2026, the petitioner would be well advised to withdraw the instant writ petition and file a fresh writ petition without prejudice to the claims so made in the present proceedings. Taking into account the above, the instant writ petition stands closed on withdrawal. It is observed that the withdrawal of the instant writ petition shall not preclude the petitioner, shall not prejudice the petitioner of the claims made in the present proceedings. And the petitioner is granted the liberty to file afresh by challenging the selections so made of Mr. Mohiruddin as the highest valid bidder.
Lordship,
So advised.
Indian Vessel Act 2021.
Or 2020, yes,
2021.
Indian Vessel Act 20.
I'm sorry.
Chalo.
Lordship, may kindly keep my instructions as a part of the record.
I've already made it X in the earlier one.
No, second one.
What is the second one?
I have,
What is that?
that they did not forward we don't have.
He has said, nah, he has withdrawn with the liberty.
Madam,
And what I have mentioned in that, make it a part of your petition.
madam. Deeply obliged.
Lordship, herein, page 44, my technical bid has been rejected on the ground that it is stated that failed to submit proper land documents submitted from other district.
Mother?
Other district. Page 44, serial number 31. 44 page.
Yeah.
Serial number 31, your lordship.
Bari Potoka ferry service.
Lordship.
For the comparative statement, it is
One,
found that
number 2, Abdul Samad, that is the petitioner.
44 even mo na eh.
all the bidders have deposited their required earnest money. The estimated bid will change. Your name is?
Abdul Samad. Serial number 2. Failed to submit
For land document.
land document submitted from other
district. Let us see the terms of the notice inviting tender.
Page 13, clause 7.
What are the documents required? Tender must deposit, tender must include.
Within the district.
Where is the land document business?
Land documents, your lordship, at page 20. Page 20.
No. What is the term out here that you are required to submit the land document?
7. Page 13, clause 7.
The tenderer have to submit certificate in support of periodic patta land in his own name within the district or the subdivision of value not less than the bid value from the deputy commissioner so and circle officer so. So you need to submit two things. One is a periodic patta
Lordship.
and also a valuation
Lordship.
of the land which is certified by either of these people.
Lordship.
To show that this land, your value is more than the tender document.
Lordship.
That is what you
That
need to do. Now, what did you submit?
Page 20, your
So
lordship.
you gave this. And where is the district?
I am from Bongaigaon district, your lordship.
Now, what district is this?
Dhubri.
Bongaigaon, Dhubri is far off, na?
No, nearest, your lordship.
Okay. But
Border.
here it says periodic patta land in his own name
Only.
within the district or the subdivision of value not less than so and so. Now you submitted from Dhubri
From Bongaigaon.
Bongaigaon.
and here the tender is for Dhubri.
Dhubri.
For Dhubri.
Can't help.
Lordship, in earlier occasion, this
Earlier, forget about earlier.
I was granted this.
Earlier is good. They have not looked into, but can't help you now. Now, if you see, Mr. Counsel, the problem lies there. Now, if they reject it, our hands are tied.
Lordship.
Problem lies there. Can't help it with this. You submitted the document from Bongaigaon. What is
Bongaigaon.
your document?
Page 20.
Yes, Jamabandi of so-and-so, district Bongaigaon. And
Then land valuation,
given
page
by
20.
Jayanto Chakraborty Chakravarti. 3 gram. Treason gram. What is this treason gram?
Season gram is revenue circle, your lordship.
Treason gram revenue circle.
Village of every town says Bongaigaon, my lord.
Treason gram revenue circle. He has given this. This is for land document. You have given the Jamabandi. Now here the tender is for where?
Dhubri.
How do you know that?
That Warghat, my lord.
Dhubri has not been stated in anywhere.
Dhubri,
That
Dhubri,
belong
Patara
to
Ferry
Dhubri.
Service.
Now you must be knowing leasing out so and so under for financial period so and so. Where is that, where do we get the ferry service?
Lordship, it's page 44, Lordship. The
Page 21.
Page 44.
Tender notice, page 21.
tender notice, page 21.
The notice. 21.
No,
Page?
pagination is not.
Sorry, page 11. Sorry, sir.
Page 11.
Serial number 22. Bagoribari Patakata.
Oh. So this Bagoribara, is it in Dhubri or where?
It's Dhubri, my lord.
It is Dhubri, Your Lordship.
Dhubri.
It is Dhubri.
So nowhere touching Bongaigaon.
Bongaigaon.
No, they're sharing the
Maybe.
border.
That is, but does any of that ferry?
I have also experienced having this service at Dhubri, Your Lordship. In last occasion, I was awarded.
Understood, but problem lies
Along,
there. Na?
Lordship.
If you admit to it that it is Bogoribari, Potoka is in Dhubri, you have to give for Dhubri.
Lordship, this is the fact, Your Lordship. This is fact, Your Lordship. I can deny, Your Lordship.
Okay, you can't help it.
Lordship,
Issuing notice makes no sense.
there is Lordship,
Lordship,
a
close this
judgment.
matter.
Lordship, a
Not,
judgment.
you see, I have not been able to issue a notice. This is the
Yes.
seventh matter today.
Lordship, if, Lordship, there is judgment. I can refer, Your Lordship. Maybe it will applicable to my case.
So we dismiss it.
Lordship, judgment maybe.
Huh?
There is a judgment, Your Lordship.
What is it?
Supreme Court. Sorry, I don't think. Copy আছে নেকি চোৱাচোন? নাই নি? Copy আছে নেকি?
What do you say?
Paragraph 19, Your Lordship.
Oh, this is different aspect. Not applicable here.
Article 14, it is Lordship. 16, 17, 18, 19. Lordship. This is gross violation of Article 17. Your Lordship.
But are you then challenging the term of the condition?
I have not challenged, Your Lordship.
You can very well do so if you can challenge the term, but you have not challenged the term.
Lordship, I have not challenged, Your Lordship. Lordship may allow to come with additional affidavit to challenge this.
No, additional affidavit, no. Then you withdraw with the liberty to challenge the term, but how can you challenge after participating?
Lordship.
After rejection in the technical bid now, he has no right to challenge that.
Oh, 1-7 has done. Now we are going to get a lot of cases from all these things. This and Panchayat will be coming.
Coming, Panchayat also coming. Your
Panchayat
Lordship.
is 1 year, okay, so we will
Now
see
this
the
ferry service
Panchayat
for
council.
3 years.
Huh?
This is for 3 years ferry service.
We see less for this, okay.
Lordship, I have not.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. So-and-so appears on behalf of the respondent numbers 1, 2, and 3.
All the respond.
The present petition has been filed by the petitioner being aggrieved by the action on the part of the respondent authorities in holding the petitioner's bid to be technically non-responsive. The brief facts which led to the filing of the present petition are that a notice inviting tender was issued on 31/12/2025 by the respondent number 3 for settlement of various ferry services for the period from 2026 to 2029. The ferry service in the present proceedings is the ferry service is the Goribari des Otoko
Kata.
Patakata ferry service, which admittedly is in the falls within the district of Dhubri. The said notice inviting tender had various terms and conditions as has been mentioned. in the detailed terms and conditions of the NIT for leasing out of IWT ferry services for the remaining period of 2026-29. Clause 7 of the said notice inviting tender, detailed terms and conditions of the NIT being relevant is reproduced herein under page 13. From a perusal of the above quoted provision, it is seen that the tenderer has to produce a certificate in support of a periodic patta land in his name within the district or the subdivision of value not less than the bid oblique tender money from the deputy commissioner oblique the additional deputy commissioner oblique Sodor subdivisional officer of the district or the subdivisional officer civil of the subdivision concerned and the circle officer on behalf of the deputy commissioner. The petitioner duly submitted the tender application on 21/2026 for the Bogoribari Des Potakota ferry service. In the tender document, tender application, what are the land documents which are what are the documents which are required to be submitted have been mentioned. Documents required to be submitted in respect to the land has been categorically mentioned as serial number 4, which includes number 1, periodic patta oblique jamabandi, number 2, valuation certificate issued from the DC oblique ADC oblique SDOS oblique SDOC and circle officer on behalf of the deputy commissioner. Number 3, NOC of the co-pattadar in the form of an affidavit duly signed by the notary. Number 4, Roman 4, non-encumbrance certificate issued from the sub-registrar's office. And number 5, the land revenue clearance certificate. Full stop. The petitioner, though submitted his tender for a ferry service which falls within the district of Dhubri, but admittedly submitted land documents as required under clause 7 of the detailed notice inviting tender, as well as the tender application, which pertains to the district of Bongaigaon. This aspect can be seen from page 20 and page 21 of the petition. The records further reveal that on 19/6/2026, a meeting was held in the chamber of the managing director, AIWCL Assam, wherein the various ferry services were the evaluation of the tenders of the various ferry services were taken into consideration. Insofar as the petitioner, insofar as the ferry service being insofar as the ferry service.
Page 44.
Page?
44, my lord. Tender committee. This is
Insofar as the ferry service.
page 44, GL number 31.
Ferry service, that is Bogori Bari Des Potakata ferry service. It is seen that there were 10 bidders. The petitioner's bid was rejected on the ground that the petitioner failed to submit proper land documents. The petitioner, therefore, being aggrieved, has approached this court. This court have heard the learned counsels appearing on behalf of the petitioner and Ms. M. D. Bora, the learned counsel, standing counsel of the IWT. The question arises as to whether, in the present case, this court should exercise its jurisdiction under Article 226 of the Constitution perusal of the minutes dated 19/6/2026, which have been enclosed by the petitioner as Annexure Roman 4, would show that insofar as the ferry service being Bogoribari Despotokota ferry service, the petitioner's bid was rejected on the ground that the petitioner failed to submit the proper land documents. In the backdrop of the above, if this court duly takes note of clause 7 of the detailed terms and conditions of the NIT, which have been quoted herein above, it would be seen that the tenderer has to submit a certificate in support of the periodic patta land in his own name, which has to be within the district of wherein the ferry service is located. In the instant case, it is an admitted fact that the ferry service, being so and so ferry service, is situated within the district of Dhubri. Under such circumstances, the document which have been submitted, that is the Jamabandi, as well as the certificates so issued, are documents pertaining to certificates so issued by the circle officer, Season
Gram Revenue Circle.
so and so revenue circle, is in the district of Bongaigaon. Under such circumstances, the learned counsel appearing on behalf of the petitioner, though submitted, that confining the land documents only to the district or the subdivision wherein the ferry service is located violates the rights of the petitioner under 19(1)(g) of the Constitution. It is the opinion of this court that for that purpose, the petitioner, instead of submitting itself to the jurisdiction of the tender, ought to have challenged the term of the tender, which have not been done. Under such circumstances, this court does not find the present case to be a fit case for issuance of notice for which the writ petition stands dismissed. No cost.
I'm so deeply obliged.
Highly obliged.
Yes, what is this, man?
My lord, kindly see annexure C, page 35, my lord. The petitioner's husband died, my lord. Thereafter, my lord,
Joy Bora has to do with some family. Those, yes. Okay, now tell me, what has happened? Page 35. Where's the impugn order? Why are you here?
my lord, page 60, my lord.
Huh?
60. Relevant portion, my lord, 61, my lord.
Speaking order. 1st August 2025, you are challenging now. We are.
My lord, the contempt was.
You want the anniversary in another 5 days.
That contempt.
Huh?
Contempt was there, my lord. Contempt petition pending, my lord. Page
Okay,
63, my
very
lord. The house was disposed on 7/4/26. So, my lord, on 27/8/21, my lord, the board of director of Kalagam Samabaj Samiti Limited, my lord, took a decision, my lord, to, my lord, transfer the fair price of license of the petitioner's elder brother to the petitioner, my lord.
No, madam, tell me one thing. Here, the basic decision was taken that she does not have 50 ration cards. How will she have a 50 ration cards? Because she didn't, she wanted a license.
Yes, my lord.
Did your husband have a license?
My lord, my lord, brother, elder brother, my lord.
Elder brother held the license.
Yes.
He died.
He died. No, my lord. My lord, he intended to transfer, my lord.
He wanted to transfer
Transfer.
to you.
Yes, my lord.
But at that time, when he had the license, did he have 50 ration cards?
Yes, my lord, it was there.
How do you show that? Because that is
My
the,
lord,
because Mr. Counsel, that is the main point.
page 60, 53, my lord. Annexure N, my lord.
Page 53. Yes.
There are another 85 benefits.
It is hard.
48, my lord, holding 48 beneficiaries. There are another 85 beneficiaries in my village added to other villages agent retailer, my lord.
It's okay. But at that point of time when your brother was using this license,
Yes, ma'am.
did he had 50?
48, my lord.
48, man.
Nothing wrong with
My
it.
lord, my lord, this one was
Can't
taken, my lord.
increase it. You see, the problem lies there. If you had 50, the question would have been different. Anyways, I think we issue notice.
Yes,
Let there be something to
We
them.
do, my
The
lord.
morning I have not been able to issue. Issue notice making it returnable on 23rd of September 2026. Miss Yudas accepts notice on behalf of the respondent numbers 1 to
1 to 4, man.
1 to 8.
1 to 4, malad. She will appear my
Why?
because BTC malad 3, 5, 6, 7, and 8.
Were 1 and 2.
1, 2, and
Four.
4.
Food and civil supplies.
1, 2, and 4, malad.
Deputy Director,
Malad
you
there.
are,
Udalguri, my friend is saying she will appear.
you are appearing. So and so appears for your your BTCs which are
5, 3, 5, 6, 7, and 8.
stop. So and so N Chaudhary accepts. The petitioner herein extra copy by tomorrow, by Monday. The petitioner herein is aggrieved by the order dated 1st of August 2025, whereby the petitioner's application representation for transferring the PDS license of her brother to the petitioner was rejected on the ground that the petitioner cannot be transferred the said license as there are not more than 50 beneficiaries who were tagged to the license of PDS license of her brother. The respondents herein shall bring on record their stand by filing the affidavits on or before 18th of September 2026.
Obliged.
May it please your lordship. Here in this case, lordship, one criminal case was instituted against the present petitioner in the year 2012, lordship, which was pending, lordship. And several litigations were filed, therefore there was delay in the proceeding, lordship. And subsequently in the year 2023, he filed an application for obtaining NOC from the concerned court so that he can apply for passport, lordship. And that trial court, lordship, kept the said petition pending, lordship, in abeyance, lordship. And according to finding no order, he approached this honorable court by filing a writ petition. And thereafter, this honorable court was pleased to direct the petitioner to file a fresh application. And with that office memorandum, the trial court was directed to consider his application. He again filed the application, lordship, which was rejected on the same ground that case is old and it is pending for consideration of charge, lordship. That your lordship will find that order at page 76.
What is the offense
302, Lordship.
and 25(1)(b)?
Lordship. And total, Lordship, 21 accused were there. Other persons are absconding, and because of that cases, Lordship, pending, Lordship.
Is there
And,
any law to that effect by which you can be permitted?
Lordship, I'm just relying on one apex court judgment, Lordship.
Okay.
That my submission before Lordship is that obtaining passport and traveling abroad are two different things, Lordship. That Ranat trial court ought to have, Lordship, granted me permission to obtain that passport, and subsequently without leave of the court, I may not be allowed, Lordship, to travel. So that part could have been done by the Ranat trial court, Lordship. Here, Lordship, I'm relying on paragraph 2, 10, 11, 13, and 14, Lordship,
Of
of that Mahesh Kumar Agarwal judgment, Lordship. An important paragraph is Lordship, paragraph 21, that finding is there, Lordship, of the Honorable
where is the Mahesh Kumar? This one.
Lordship.
What does it say? Where?
Lordship, may I kindly see paragraph 21 and 22, that observation, after discussing all the provisions, Lordship.
But Mr. Counsel, why haven't you approached why are you here under 226? Because this is an order passed by the criminal court.
Lordship.
Why have not moved under 482?
Because Lordship,
Or
I have also
revisional
filed,
jurisdiction?
while my application was kept in abeyance, Lordship, I filed application for obtaining that passport. That was also rejected, Lordship. Only on that count, without making any inquiry, Lordship.
Therefore, you had to take the leave of the court. I
Lordship.
think there is another judgment where
Office
it is
memorandum
where
is there, Lordship.
that
That
criminal trial
Yes,
court, you
my
have to take the leave.
Yes, my lord.
Lordship.
Yes, sir.
That is there. So the order of the trial court may be wrong.
Lordship.
Therefore, why you are not before that criminal court? Why should we exercise a writ over the order passed? Because here we can issue a writ. We cannot exercise a revisional jurisdiction.
Lordship.
So why should we entertain this petition? Rather, why are you not approaching there before the court? But they are different jurisdiction. My question is there.
Lordship. Lordship. Because, Lordship, here one office memorandum is there, Lordship, which.
Understood, but the law makes it very clear. There are judgments to the
Lordship.
effect that if there is a criminal case pending, you have to take the leave from the trial court.
Lordship.
So the leave, when you sought for the leave from the trial court rejected your application.
Lordship.
So therefore, wouldn't it be right on your part now to move under earlier 482 or
482.
revisional jurisdiction,
Now
whatever
520.
may be, before the high court, the high court in this, then to move under 226? How can we issue a writ upon a court?
Against that order, I can file, Lordship, criminal petition. But here, Lordship, my another pleading is also there, that when I applied for passport and if it is rejected, they have to intimate the person in writing. That has also not been done. That's why my application was rejected.
So then we only limited there.
So in that case,
I'm not
Lordship,
going to look into the other one. Make it very clear.
no, in the,
Then you will be two proceedings.
because of that, both I have filed writ, Lordship. So.
No. Because of that, a jurisdiction which does not lie here. Because I remember taking up another matter where I sent it out there to the trial court to look into it. Yes, you may have a case out there to the effect that how long can it go on?
Lordship.
But the offenses are also, we need to look into it. It's a case under 302.
My submission for Lordship is that trial court can direct the issue NOC with condition that immediately after obtaining a passport, I will submit it to the trial court, Lordship. And after that,
Why do you need a passport then?
no, after that, Lordship, after obtaining permission from the court for traveling, I will use that passport, Lordship. Because Hajj is, your Lordship, is known that it is in a particular period, Lordship. In the year 2023 also, during Hajj period, I was trying to get that passport, Lordship. I could not obtain in time, Lordship. So since then, in 25 also, I could not obtain in time. So at best, I can be allowed to obtain the passport. I will deposit before the trial court it, and whenever it is required, with permission of the court, I will leave for travel, Lordship. So two different.
But there again, one has to interfere with that order of the trial court.
Lordship.
Can I interfere under two?
Like, yes, well, few days back, some of the authority were before the trial court for this type of subject matter, my lord.
Understood. So
Yes,
how
my lord.
can I interfere? My question is that. Think about
Yes, sir.
you can issue a notice, but the fact remains that will be further delayed. Question of maintainability, because you need to in fact challenge the trial court's order, get an order there. I think you have a good case. The trial court did not apply its mind.
Lordship.
But this is a perception of a person who is all along taking up writ proceedings.
Lordship. That.
But the court which normally takes up the criminal cases, they think it is on a different manner.
Lordship.
You have a good case. So the trial court ought to have passed to that affair, granted the leave and thereafter, because there is a Supreme Court judgment, if I remember, that when a matter is that the permission from the trial court is required.
Lordship.
The permission from the trial court is required, the trial court ought to have analyzed this aspect.
Lordship. That was the direction of earlier, in earlier litigation
Now,
also.
if we pass an order to that effect that let the trial court look into, by taking into account this judgment, trial court let them there. The trial court may apply its mind. But would I be the proper judge to do so, taking into account I'm exercising 2 to 6? I think that is the best order you can get. But can I pass that order? Because if I exercise this jurisdiction all along, I'll have to exercise.
Yes, sir.
And you see, this there is always a big problem. For me, it is a single. For you, it's a single case where I'm exercising the jurisdiction.
Lordship.
Tomorrow, what happens? Because of that, many other cases come, and I can't say no because I have done it with you.
Well, can it be taken up on Monday? Because what the judgment which I have searched, Lordship, all were filed, writ petitions were filed. So I will clarify this aspect on Monday, or I will withdraw, Lordship, on Monday. Only to that.
The request of the learned counsel for the petitioner matter stands adjourned to be listed on Wednesday, Monday, on Wednesday.
Obliged, Lordship.
May I please, your lordship.
Matters regarding non-payment of contractual bills, Lordship.
Which year?
25, apparently they have completed the work, Lordship. The supply.
This is a notice. Returnable on 25th September.
I'm paying for all the respondents.
Obliged, your lordship.
May it please, your lordship. Account freezing matter, your lordship. Account freeze.
Huh?
Account freeze, your lordship, because of a cyber complaint.
Notice making it the 8th August 2000. A client accepts notice on behalf of the respondent number 1. Extra copy of the writ petition be served upon her during the course of the day. As the respondent number 2 and 3, steps be taken by way of speed court by Monday. The petitioner is the account holder of a savings bank account number 409630111690 held in the State Bank of India Jagi Road branch. Full stop. On account of a complaint issued by the Police Cyber Cell Bihar. Mr. Counsel, why haven't you make that Police Cyber Cell a party? Flipping the papers would not help you.
I'll make them a party then.
Then file a fresh one. You're making them a party. Because again, you implead, again file anything. So file a fresh one and make them a party. So we have to issue notice to them also.
Yes.
And in the meantime, madam, you have I'm taking up one matter on, what is the date of the matter? I think on 12/8 me. See, now the Ministry of Home have issued a circular. Another license integrated. And Mr. Counsel, why don't you take that help? Immediately they do it within 90 days, everything is clear.
I'll look into it.
There is a circular. Ask him, he will give it to you. And by that you can approach the state bank in terms with that. The state one will contact with the police officers and thereupon they will defreeze it by keeping it in lien. There is already a circular issued by the Ministry of
Ministry.
where?
No, my lord.
In the Roshonara Massachusetts. Matter came up on Wednesday. On Wednesday listing. Ali no, Wednesday listing. Now, the union government have issued a circular. There's also a circular which has been issued requesting the high courts not to interfere to the affair and encourage the people to approach the grievance redressal mechanism,
Yes, sir.
which every department, every bank is required to have.
Yes, sir.
This was issued on 2/1/2026.
2-1, yes, sir.
Another decision अपनी उलाई दिसिल integrated है तो कौन कोलेगा? Integrated के कौन से असेल? कौन print out लेटर रख? Topic. Page 38 of the SOP.
Just take it.
It is 38. Section 3. It is section 2 है. Section 3. तोलो side of 30. Yeah. Grievance redressal mechanism. That all to 10(1). A2. In case of grievance related to amounts put on hold affected by so and so, the following process will be followed. Down को इडियो. Bank branch where her account exists or any other designated branch of the office, the bank will undertake CCD as prescribed in the relevant RBI circulars area updated from time to time. And if convinced about the bona fides of the matter, submit the grievance to the so and so with the necessary banks and FIs will be expected to submit such grievance at the earliest and not beyond 7 days from the date of the aggrieved person. The grievance will be assigned by the concerned SO2 to the so and so or the police officer under inquiry. If there are multiple holes, grievance will be assigned by the so and so to so and so. The IO of the so and so, they shall verify the grievance. She will issue a notice physical alia to the account holder in whose account the reported amount is put on hold to appear for verification, preferably through video conference. A representative of the aggrieved party so and so preferably may also be included in the video conference. Account holder or the person raising a grievance or demand, unless deemed to be applicable during the course of the investigation and an FIR or to the hoc. Verification here for this, the Iman so and so platform here, if the IOSO is not satisfied with the explanation submitted, with our remarks and so, then within 15 days, the reviewing officer can file a review. 15 days, and in case of lawful directions regarding continuation or discontinuance of the hold of money and so and so, so and so. Carrying out the discontinuation, intimation will be sent to the EI at least 15 days before the date of expiry. 90 days from the raising of the EI. So 90 days, everything is to be done. This is the EI relating to suspension of digital banking service or seizure of accounts or so and so. This is how it is to be done. So therefore, you look into this, take a copy from him, soft copy, and then advise your client properly.
And Your Lordship, may I make a prayer that Your Lordship may dispose of this petition, directing that the petitioner may take steps as per this. I'll annex the order, then and I'll send it to the bank.
Think better.
Yes.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. Agayan appears on behalf of the respondent number 1. The petitioner herein, who is an account holder, bearing savings account number 40963011690 with the State Bank of India, Jagirod branch, is aggrieved by the freezing of the petitioner's bank account on the basis of a complaint
104 cases.
on the basis of an instruction received from the police cyber cell Bihar in connection with NRCP cyber complaint number 30509250065496 dated 25/9/2025 with respect to the alleged credit of a disputed transaction amount of rupees 12,000 dated 25/9/2025. The petitioner thereupon submitted representation to the respondent authorities, to the respondent number 2 and 3. However, the said representation as well as the submitted a legal notice as well as the representation to the respondent number 2 and 3. However, the representation as well as the legal notice having not been acted upon, the petitioner has approached this court by filing the present petition, seeking a direction that the amount of rupees so and so 24,512.88 that the amount of rupees 12,000 seeking a direction that the disputed amount may be kept in whole, thereby permitting the petitioner to operate the bank account. একদম উপরে যাও, page 1 যাও, একদম 1 তলে হব এই নামটো দেখাওক না, নামটো দেখাওক. This court duly takes note of that the minister ওপৰত common court নামটো আছে takes note of that the Indian Cyber Crime Coordination Center of the Ministry of Home Affairs have issued a standard operating procedure bracket SOP for NCRP-CFCFRMC MS from a custody restoration of money and grievous redressal dated 2/1/2026. Full stop. In chapter 3, in section 3, in section 3, okay. In section 3, more particularly, clauses 10, in section 3, the grievance redressal mechanism has been categorically mentioned. Full stop. Taking into account that there is an grievance mechanism set up in view of the SOP number so and so 2016 issued by the Ministry of Home Affairs. It is the opinion of the petition of this court that the petitioner would be well advised to approach in terms with the grievance redressal mechanism set out in the SOP dated so and so. Accordingly, without prejudice to the petitioner's claims made in the instant with petition, this court is not inclined to entertain the instant with petition, thereby granting liberty to the petitioner to approach the grievance redressal mechanism in it, the SOP so and so, dated so and so. It is further observed and directed that if the petitioner approaches in terms with the provisions stipulated in section 3, Roman 3 of the SOP dated number so and so, the concerned authority shall duly take steps in accordance with the said mechanism. You're gonna print out it all up. What is this?
My lord, in the earlier, I'm sorry, my lord, may I submit, my lord? In the earlier round of litigation, my lord, your lordship had directed to verify the commissioner, because the earlier the BDO has verified and admitted the total amount of 21 schemes, and your lordship had directed that the commissioner should verify. Accordingly, commissioner had verified, my lord, and it is found that out of 21 scheme, they have admitted that 14 scheme is found to be, I am entitled to get the fund, my lord. But due to several communications during the contempt proceeding, it is held that, my lord, your lordship will find at page number 197, your lordship. Kindly for a 197 page number, where it is admitted that the petitioner is entitled to 14 schemes.
And there cannot be a willful and deliberate to the other duty.
197. Paragraph 2. Thereafter, my lord, the commissioner has directed for ascertaining the amount of the 14 schemes.
Now, what has happened?
Thereafter, my lord, kindly page number 206, my lord. The amount is also, my lord, ascertained 206 by the deputy commissioner as per report of the BDO, my lord. 205, the BDO, my lord, submitted the amount of the schemes of 14 schemes, and accordingly the deputy commissioner, page number 206, my lord, held 2 paragraph may I read, my lord, 206.
Here it says that the claims of a petitioner regarding the completion of 14 schemes cannot be substantiated.
Page number 206, my lord.
Page number 257.
My lord,
page 257.
My lord,
Is this the order you are challenging? 12-6.
That is, my lord, but my lord, 257.
Understood.
Yes. Yes,
I have therefore directed in this matter that asking the commissioner to make the verification.
Yes.
The commissioner made the verification saying that these were not uploaded.
Yes.
And as such, we reject it.
Yes.
Okay. Now, what has happened when this happened in the contempt proceeding?
Yes,
That pursuant thereto, kindly see page 261.
261.
Yes.
Yes, my lord.
It appears that this court has specifically directed the commissioner and rural area to verify whether the petitioner was entitled to the amount, and only upon verification and upon finding that the petitioner was entitled to the release of the said amount, the court had directed the said exercise be completed within the period of 4 months. Then I write all these things. Then it kindly come to paragraph number 8. Also takes note of the order dated so which is kept on record and marked with the letter Y. On perusal of the said order, it appears that the commissioner so, after carrying out the verification, came to an opinion that the petitioner claim regarding completion of 14 schemes could not be substantiated. Further to that, it was also mentioned that after observing all the records, it revealed that the commissioner did not admit any liability to pay any amount to the petitioners contrary to the 14 schemes. Considering the above, it is therefore the opinion of this court that the panchayat cannot be, so I drop the contempt proceeding. Before parting with the record, this court, however, observed that the dismissal of the alia shall not prejudice or preclude the order from challenging the order dated so, as well as file appropriate proceedings for realization of the said amount of rupees so before a competent court of civil jurisdiction.
Yes, madam.
Now you are challenging
Challenge.
12-6.
Yes, madam.
So you don't want to file the civil suit.
We'll suit, my lord, regarding the 7 schemes, my lord, because 7 scheme is disputed.
Oh, I have your total
Your lordship-
76 lakh.
Yes, your lordship is granted the liberty, but my lord,
Therefore, now you do it with there won't be any more time granted after this notice being issued. You forego your right in respect to the civil suit. Because you have to prove that.
Yes.
Why you're not going before the civil court and asking for proving out there?
my
How,
lord, it
this
is,
court cannot look into it. The court you see the court directed that you make the verification and make the pay. Okay.
yes,
The court pursuant thereto, they did not carry out any verification. Various affidavits, some affidavits were
they have
filed.
carried verification.
Understood. Thereupon, when I directed the commissioner to make the verification as to whether the petitioner is entitled to any amount, it was brought to the notice of this court by an order dated 12-6 that they are not entitled to the amount. Now you want to challenge that order.
Yes,
On the question of fact, it's a question of fact, Mr. Kadir.
yes,
If it is a question of fact, if you challenge that order, we will look into it.
yes,
But your total claim is 76 lakhs.
yes, yes, ma'am.
So why you are not going before the civil court and asking for this and filing this petition? Your dues are long back.
Yes, ma'am.
How will you get if your petition is dismissed, what will happen?
My lord, 65 lakh is, my lord, admitted, my lord.
So go there.
Because the amount is admitted amount, my lord, that after verification, they have found that I am entitled, my lord. 65
Understood.
lakh.
But later on, after verification, they found that you are not entitled to.
No verification is made thereafter, my lord. After your lordship's order, no verification is made, my lord. Before the order, all the verification is made, my lord. And this order is passed, my lord. All the verification made before your lordship's order, my lord.
You know, we issue notice, but we take away the limitation. At your risk, you are doing.
Oblige.
Okay?
Oblige.
Later on, don't say this. I'm making it very clear.
Maintainability may be kept open, madam.
The maintainability, it's okay. We are only going to look into 12-6. You are not going to get any payment here.
Yes.
Making it very clear in my order that you are not going to get a single penny here. Issue notice making it returnable on 7th of October 2026. Mr. S. Doctor accepts notice on behalf of the respondent numbers 1, 2,
1, 2,
4, 5,
4, 5,
6,
7.
4, 5, 7,
6 also I can, madam.
6 and 7. Ms. Yudas accepts notice on behalf of the respondent number 3. But are you not also the district program coordinator? No.
Yes, madam.
So 3 also. It is given as
No, madam. District commissioner is the.
district commissioner. He is also the district program coordinator. They cannot say anything.
That is also there, madam.
But I think you need to look into it.
No.
So you take notice for all. 1 to 7. Extra copies of the writ petition be served on or before 28/7/2026. The present writ petition has been filed pursuant to the leave so granted in the order dated 15/6/2026 passed in con case number 52/2024. It is relevant to take note of that the petitioner claims that he had completed
Supply of materials, my lord.
He's
a vendor.
supplied materials to whom?
To the my lord, block development officer, my lord.
To the block development officer
Borokola development block.
in the year
Year 1617 and 1718.
in the year 2016-17 and 17-18 to the tune of rupees 76,18,804. Pursuant to the filing of the said writ petition, pursuant to as there was no payment so made, the petitioner filed a writ petition before this court, which was registered and numbered as WPC number. Where is that order?
110, my lord.
Ah,
Page
no,
number,
no,
my
no.
lord, 110.
4511.
Yes, my lord, yes.
Filed a writ petition which was registered and numbered as 4511/2021. Where is that order?
My lord, page number 110, 110.
The said writ petition was disposed of by this court by an order dated 23/8/2023, thereby directing the Commissioner Panchayat and Rural Development Department to carry out the verification as to whether the petitioner was entitled to the amount of rupees 76,18,804. And upon making necessary verification, and if it is found that the petitioner is entitled to, the said amount be paid to the petitioner. This court further directed that the said exercise be completed within a period of 4 months from the date a certified copy of the order was served upon the Commissioner Panchayat and Rural Development Department. The record reveals that thereupon affidavits have been filed and a contempt application was filed on account of non-compliance to the order dated 23/8/2023 passed in WPC number 4511/2023. So in the said contempt proceedings, an order was placed before this court on 12/6/2026, wherein the Commissioner, Panchayat and Rural Development Department had categorically denied that the petitioner was entitled to any amount any amount as the claim of the petitioner could not be substantiated before the Commissioner, Panchayat and Rural Development Department. When the said order dated 12/6/2026 was placed before this court, on 15/6/2026, this court passed an order. This court closed the said contempt proceedings, being contempt case number on case C52/2024. However, granted the liberty to the petitioner to challenge the order dated 12/6/2026, as well as also file appropriate proceedings for realization of the amount of rupees 76,18,804 which was the claim of the petitioner in the writ proceedings against the respondent PNRD department. This court further observed that the period during which the writ petition being WPC number 4511/2021 was pending, as well as the period till pending and till 15/6/2026, the period of limitation would be excluded. The petitioner herein has approached this court, therefore, challenging the order dated 12/6/2026. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether a civil suit has been filed in respect to the said amount of rupees 76,18,804, whereby leave was granted to the petitioner. It was mentioned by Mr. M.J. Kadir, the learned counsel for the petitioner, that the said amount for no civil suit has been filed. This court, though have issued notice, but makes it very clear that the petitioner have approached this court challenging the order dated 12/6/2026 at its own risk, as the petitioner have not chosen to file the suit. Under such circumstances, under such circumstances, it is the conscious decision of the petitioner that the petitioner would not like to approach the civil court. It is the conscious decision of the petitioner that the petitioner would avail remedy only before avail remedy before this court. And as such, the petitioner would not be entitled to the benefit of Section 14 of the Limitation Act 1963. In the circumstance, this court at a later stage is not inclined to entertain the present petition. This court further puts to notice that the of the petitioner that the maintainability of the present petition is kept open.
May I please?
Yes, Mr. Rahman.
Here, my lord, the Chief Executive Officer, Dorong Jila Parishad, my lord, instead of issuing an NIT for settlement of market, he has allowed the ex-lessee to run the market until further orders, which is the impugned order in that present petition. In this page, my lord, 63, that the impugned order. 63. Which is clear violation of common judgment of this honorable courts as well as section 1055 of this act, madam. In this regard, madam, several similar order is there.
It is.
Yes, ma'am. Yes.
Notice making it returnable on
Similarly, order of social page 71. Exactly similar.
24th of August 2026. Mr. S. Datta accepts notice on behalf of the respondent number 1, 3, and 4. Mr. S. R. Bolwa accepts notice on behalf of the respondent number 2. The petitioner, who is an aspiring bidder,
intending tenderer,
whichever word you want, intending,
yes, well,
who is an intending tenderer to the settlement of the What is that?
Alika's daily vegetable market.
So and so, Alika's daily
Daily
vegetable
vegetable.
market is aggrieved by the actions on the part of the Chief Executive Officer Dorong Jila Parishad in permitting the ex-lessee to continue collecting the tolls with effect from 1/7/2026 until further orders by the impugned order dated 1/7/2026. Inasmuch as it is the case of the petitioner that the said order is in complete violation to section 105
5.
of the Assam Panchayat Act 1994. So Mr. B. Rahman, the learned counsel appearing on behalf of the petitioner, submits that the Panchayat year having ended on 30/6/2026,
Right.
it was the incumbent duty on the part of the respondent authorities to go to put to auction the said market rather than permit the respondent number 5 to run the said market with effect from 1/7/2026 until further orders. This court, having perused the materials and record, is of the opinion that the impugned order dated 1/7/2020 is prima facie of the opinion that the impugned order dated 1/7/2026 appears to be contrary to the provisions of section 105 of the Assam Panchayat Act 1994, and it also appears to this court that an attempt had been made to grant the permanent settlement in favor of the respondent number 5 by the impugned order, inasmuch as the impugned order has been made effective from 1/7/2026 until further orders. Consequently, it is the opinion of this court that such action on the part of the respondent authorities cannot be allowed. Accordingly, this court, in view of the prima facie opinion expressed herein above, stays the impugned order dated 1/7/2026, which is Annexure D to the present with petition. Full stop.
And my lord, further regarding arrangement part also, section 105 is very much clear. It should be run by the Jila Parishad.
1055 is there.
1055 is there.
No, not necessary. They don't want it.
My lord, that
You
may
don't
be.
buy it because you have a lot of money. Why you are not going for auction?
Public will suffer, but
No,
that
the
is,
public is nothing
my
to
lord,
do.
for an attender, my lord.
We stop you from collecting because you don't want to do it. You are doing it for the benefit of somebody.
No, my lord.
Why haven't you put on auction this particular market?
My lord, in the
You
whole,
should have put on auction this market instead of giving it until further orders.
my lord, because of government instruction, they are not issuing, my lord, because in the whole state, my lord, we are not issuing because of some government instruction. These cases will become infructuous after a few days, my lord. Item, my lord, 66 same, my lord. Exactly same, the market name is different.
You are paying 66 also.
63. 62 and 63. Market is different, my lord.
62 and 66.
66.
It is however observed
It's 63.
that the
62.
stay, the stay of the impugned order shall not affect the rights of
66.
the Dorong Jila Parishad to run the said market on its own without involving the respondent number 5.
My lord.
Next, my
Well,
lord,
63 is also same, only name of the market is different.
Name but like
All, that is, my lord, Aligarh weekly cattle market. Date of the imputed order is also same? That is so. High level, high level.
A non-payment of contractor bill Miller.
Which year?
Miller, a last communication is 2026 Miller. January 2026 Miller, last communication Miller.
Payment from?
2022 Miller. Completed
Mission
work.
Director, Swatch.
21 is
Sarah.
Swachh Bharat Mission Miller. IHHL Miller.
PHE is not here, na?
21.
All these three people will be appearing, the PHE. We have it on Monday, taking into account the Council for the Public Health Engineering Department has not appeared, comma. This court has adjourned the matter to be listed again on Monday. Monday, no, Wednesday.
Okay. Obliged.
May it please your lordship, come against the order of the authority under the Minimum Wages Act, my lord. We had taken some cars, vehicles for hire. And there is an allegation that the drivers were not paid the minimum wages. So we have been saddled with the liability holding that we are the principal employer, my lord, by bringing the concept of principal employer from the Contract Labor Act. My contention is that we are not the employer. There is no employer-employer relationship. So therefore, the issue
Where
before
is the order?
the order, lordship will find at page 55. Issues at page 56. Issue would be, my lord, whether it is a contract for service or it is a contract of service, my lord. It has been held that I am the employer.
Okay, we should notice. Let's see.
My lord.
Who are the parties?
Still labor, the authority under the Payment of Wage, Minimum Wages Act and the drivers, my lord.
There are parties there.
They are parties there.
They're working under whom?
They are contractors, my lord, not the drivers. They are the contractors.
They are the owner.
They are the owners of the vehicle.
Vehicle owner.
Vehicle owners.
So your question is whether you should pay or they should pay.
My contention is that I have taken the entire vehicle on hire. I have not engaged the drivers through the contractors, my lord. So I am not the employer. That is my contention.
How much is the amount?
The amount with penalty is a huge amount, my lord.
How much?
Lordship will kindly turn to page 60, my lord.
How much?
And now the demand has been made at page 68 of 24 lakhs. And this also is without jurisdiction, my lord, because this says that it is under the Payment of Wages Act. Because the process of recovery under the Minimum Wages Act is different, my lord. It is under 20. Because the penalty is 100%.
Minimum. Where is the adjudication? Yeah?
Section 20. Lordship may have a look at subsection 5, my lord. That is the recovery part. Subsection 5. How it is to be recovered.
Subsection 5 of?
Of section 20.
Of?
Section 20 of the Minimum Wages Act. How it is to be recovered, my lord. If the authority passing the order is a magistrate, then he will himself do it. If not, then he'll write to the magistrate to recover, my lord. And the notice has been issued under the Payment of Wages Act.
So here you mean to say that the provisions of the Wages Act cannot
Will not
be
come.
employed?
That will be a separate proceeding under the Payment of Wages Act.
So your basic case is there is no employer-employee. So if there is no employer-employee, you are not liable.
I am not liable.
And how do they look into that aspect?
They say that I am the employer. That finding is at Lordship issue number 257.
Vehicles are placed at the disposal of the general manager. Main on 24 hour. To notice making it returnable on August 21st, 2026. Favor? Labor Department, who appears?
Government of
Gov-
Government of
Central government, my lord.
No, no, not central government. State government.
State government.
Ms. Yudas, the learned petitioner, senior government advocate, accepts notice on behalf of the respondent number 1 and 2.
No, 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 central government or not?
Extra copies of the writ petition be served upon her by Monday. As regards the respondent number 328, steps be taken by way of speed post on Monday. That this court further directs the petitioner to effect service upon the respondent number 328 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner had entered into an agreement with the
Not one
respondent
agreement, my lord.
numbers
Different agreements. Different agreements, not one agreement.
have entered into agreements with the respondent numbers 328
328.
for providing vehicles on hire. In the agreements, there is a clear stipulation that the driver of the vehicle is to be arranged by the supplier, and the payment of the driver will be made by the supplier and should always be available at call on 24 hours basis, including Sundays and holidays. On the ground that the drivers of the vehicle have not been made payment of the minimum wages, a proceedings was initiated by the respondent number
1, my lord.
1 on applications filed, which was registered and numbered as PWA case number 4/2023. The petitioners who were put to notice appeared and raised the categorical issue objection in the said proceedings, squad of petitioners, that they are not the employer, and as such, they are not liable to make payment of any wages to the driver. The respondent number 1, thereupon, however, decided the same against the petitioner and directed the petitioners to make payment of an amount of rupees 24 lakhs
12,388.
12,388 as the dues payable to the various drivers. The said order was passed on
23/4.
23/4
4, 2026.
2026. And the petitioners were directed to make the payment within a period of 30 days. Mr. Endeka, the learned senior counsel, appearing on behalf of the petitioner, submitted that the said amount could be realized in terms with section 25 (5) of the Minimum Wages Act 1948. But however, the respondent number 1 have resorted to the proceedings or the provisions of have resorted to realization by invoking the provisions of the Payment of Wages Act 1936, which is contrary to the provisions of the Minimum Wages Act 1948. This court, upon hearing the learned senior counsel for the petitioner, is of the opinion that a debatable issue have been raised as to whether, on the basis of the terms and conditions of the agreement entered into by the petitioner with the respondent numbers 3 to 8, can the petitioners be said to be the employer and thereby liable to the Minimum Wages Act, liable to make payment of the minimum wages? Considering the above, this court, considering the above, this court is of the opinion that the petitioner has been able to make a prima facie case, and also, in addition to that, it is also the opinion of this court that if a stay is not granted and the petitioners are compelled to make payment, the petitioner later on would not be able to recover it from the respondent number 3 to 8. Consider, in that view of the matter, this court stays any recovery from the petitioners on the basis of the order dated 23/4/2026 by the respondent number 1 in PWA case number 4/2023 till the next stage.
I'm obliging.
Item 14. 14. 1-4.
May I please do that? Lordship, kindly page the last order, Lordship, 15/7/2026, Lordship.
None has appeared on behalf of the contemners, and a final opportunity was granted to the counsels for the respondents to obtain the instructions on 15/7/2026. As the contemners have not been represented, nor have filed the affidavit, this court directs that the contemners be personally present before this court on 19th of August 2026 at 10:30 a.m. and explain as to why contempt proceedings should not be initiated against them. 26th of August 2026. The registry is directed to issue send a copy of this order. Copy of this order be served upon the registry is directed to serve a copy of this order upon Mr. P.N. Goswami, the learned standing counsel of the PHE department, for due communication to the respondent numbers 1 and 2.
Obliged.
May I please, Your Lordship? My lord, may I kindly have the order dated 28/5, the last order dated 28/5.
As per my lord's direction, we have filed affidavit also.
What has happened? Is he entitled or not?
Also, he is entitled for also 8,82,000. That was already given to him also.
He's not entitled to any money.
Other part, we have explained, Lordship, in paragraph 2 of our affidavit, Lordship.
It is found that an amount of AI is payable to the, in that regard, a statement has been placed. A earlier so-and-so submit the financials and list the matter on so-and-so, give an update as to whether so-and-so has been disbursed. You got 882?
Yes, my lord, 882 I got.
Then what remains?
My lord, 3 lakh, the 3,27,870 for the remaining amount.
It is seen that the respondent number 2 have endorsed the stand as would appear from my for the was taken by the concerned respondent to the litigation case to what the present respondent number 2 thereby swears. Now, have you filed an affidavit pursuant?
We have filed, Lordship, we have filed.
What happened? What
We
do
have
you,
filed
what do you
affidavit,
say?
paragraph 2 we have stated, Lordship. My lord, may
Whereon, page
page 32,
dated 22/6.
page 32 onwards, Lordship.
Page 32 onwards.
Then my lord may directly come to 3, Lordship, Roman 3 next page, Lordship.
That according to the notification, the hiring of buses of mini up to so and so is rupees so and so per day, and the wage of the driver and human is so and so per day, and the vehicle have not submitted the bills as per the based upon the instead of so and so. So you applied the government notification.
Lordship, Lordship.
And thereupon you made payment of 8.
Lordship, Lordship.
He is entitled as per the government notification
Lordship, Lordship.
and not beyond that.
Lordship, Lordship, Lordship.
May I make a submission, Lordship? My lords may kindly have page 15 for a while, my lords, of the impugn order. Page 15 of the impugn order. In fact, my lord, while passing the order, this court, my lord, had specifically asked them to clarify what is the amount due. My lord, they came up with 12,05,874 at paragraph 4 and 5. My lords, may kindly have paragraph 4, paragraph 5. There was a specific direction to verify the amount. My lord, they could have filed the review, appeal, nothing is filed. How can they, my lord, come up with such a contention in a contempt petition?
You do one thing. What department is this?
My lord, Home and Political is the one, my lord, sanctioning the funds.
You do one thing. Take the money from S. Burwa, counsel, who made that submission. The money and take the amount from them. There has to be a sense of responsibility.
Otherwise, probably he has submitted on the basis of that particular time instruction without verifying that was given probably. Otherwise,
And the problem lies with that order.
Otherwise, we cannot.
Whenever I pass an order, in spite of those instructions, I ask them again to verify by higher authority.
Otherwise,
But the same thing was done here also.
Otherwise, we cannot go beyond this, Lordship. As per his entitlement, he is getting.
Counsel for the respondent has submitted that issued by the office of the Iman an attached statement of pending bills of the petitioners, which is to the effect of
Lordship, bills he has given.
My lord, this
all
instruction
bills are
was
forwarded on the basis of that bills without verifying their statement was given. Lordship, that is the reason. Lordship.
No, my lords. They
Otherwise-
verified the statements, and that was made a part of
Otherwise,
the
Lordship,
record.
he is entitled for 8,82,000. Beyond that, Lordship, government money, Lordship, cannot be given. Lordship.
So, my lords, they could file a
Cannot be
review.
given, Lordship.
But therefore,
Beyond
take
that,
the
Lordship.
money from Art Talukdar. Who is that? The money from him. Dues, the government
Lordship,
be payable to Mr. Art Talukdar.
not only Art Talukdar, Lordship.
Eh?
Not only Art Talukdar, Lordship.
Many.
See.
We have it at 2, but very difficult, Mr. Counsel.
My lord, but they ought to have filed the review petition, my lord. Appeal
No,
the
the court
contempt
should not have,
jurisdiction, my lord.
see, with due respect to the coordinate bench, when they are saying that the dues are pending. At least see paragraph 5.
My lord.
What is his instruction? What he played? An attached statement of pending bills of so and so, which is to the effect that the outstanding dues payable to the so and so for the payer.
My
So
lord.
this is what is the pending bills.
My lord.
He has given a statement.
My lord.
Who is going to make the payment?
My lord, the Home and Political Department. My lord,
Therefore, if it was by the Home and Political Department, it was the Deputy Commissioner could not have given that.
my lord,
stand.
even respondent number 7 is the Home and Political.
Where?
In paragraph 5, Respondent number two,
No, no,
three, and
no, no,
seven.
you are not understanding.
My lord.
This document was issued by the District Commissioner Gwalpara.
Yes, my lord.
So therefore, he could not have said so.
My lord, rightly, wrongly, this order has been passed. They can.
I
they can-
am with a wrong order, I am not going to allow you to get more money. Sorry. My conscience does not permit. You are not going to get it. If you want about the additional money, go to the civil court. Before having our lunch at 2, I need to finish up this episode right. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petition. The present application has been filed alleging willful and deliberate violation to the order dated 10/6/2025, passed in WPC number 3870/2024. This court finds it relevant to take note of the directions which were passed by the learned coordinate bench in the order dated 10/6/2025. Paragraph 4, 5, 6, and 7 being relevant are reproduced herein under page 15 and 16. It is seen from the records that out of the total amount of rupees 12,05,874, which was directed to be paid within a period of 3 months, an amount of rupees 8,82,000 have been duly paid. This court, by an order dated 25/2026, inquired with the respondent number 2, 3, and 4 as to why an amount of rupees 8,82,000 is stated to be the liability payable to the petitioner, when it was categorically mentioned that the petitioner was entitled in the writ proceedings that the petitioner was entitled to rupees 12,05,874. In that regard, an affidavit has been filed by the respondent number
3 and 4 also.
by the respondent number by the District Commissioner Gwalpara on behalf of the respondent number 3 and 4, wherein it is categorically mentioned that the petitioner, though had submitted the bills of rupees 12,05,874, the said bills were mentioned as pending when the writ proceedings was taken up. It was further mentioned that at the time when the petitioner submitted the bills, the petitioner calculated the amount not in terms with the government notification dated 6/2/2014, wherein the hiring charges of the minibuses up to 20-seater (force traveler) is rupees 1375 per day, and the wages of driver and handyman were rupees 250 and rupees 150 per day. On the basis of that notification, the petitioner's entitlement was only rupees 8,82,000. Taking into account the said explanation, it is the opinion of this court that the present contempt proceedings cannot be further proceeded with, as there is no willful and deliberate violation of the order dated so-and-so, passed in so-and-so. Accordingly, this court therefore dismisses the contempt application. So before parting with the record, this court, however, observes that if the petitioner is aggrieved with the amount, it shall not prejudice the petitioner on account of the dismissal of the contempt application to approach the competent court of civil jurisdiction.
All submission. My lords, may I kindly record my submission. With regards to my lords, they could ought to have filed a review petition.
You saw the video?
My lord.
You saw the video?
My lord.
Wherever it is necessary. I'm not going to look.
Just my lord, on my way, I was in the middle of a hearing, my lord, at 19, court 19.
There are many more counsels PHC had only one council. There was another motion matter we could not take it up because of the PHC council not there.
And today, some of the councils could not come, my lord. Some of the councils, because of the flood, my lord, could not come. So I'm a little handicapped, my lord, today.
Okay. Due to the, why haven't you got the instructions?
Instructions I have received, my lord, that the fund demand has been rejected, my lord, for insufficient funds. by
In the
department,
contempt,
My lord.
what is
That-
that? We'll have it on next Wednesday.
Next.
Mr. Item to the personal appearance issue. Mr. Ibo Thakur, the learned counsel submits that on account of the floods, Mr. R.R. Gogoi, the learned counsel, who is appearing on behalf of the respondents, could not appear today. So taking into account the above, list this matter on 29/7/2026.
Obliged.
Copy has been supplied to us, Lord. Copy has been given. Online.
Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner, and Mr. M. Smith, the learned counsel, who appears on behalf of the respondent numbers 1 to 4. Present proceedings have been filed challenging the actions taken by the respondent authorities on the basis of a prohibitory order. Prohibitory order, na?
Yes, Lord.
Prohibitory order dated
That would be 27/4/2026, page number 34,
7/4/2026.
2026.
2026. Issued by the respondent number
Respondent number.
Respondent number
Two, Lordship, recovery officer.
Respondent number 2. Respondent number 2. It is seen that the prohibitory order dated 27/4/2026 is based upon an order dated 29/10/2025
Under section 45.
passed under section 45 capital A of the ESI Act 1948. Mr. So-and-so, the learned counsel for the petitioner, submits that no copy of the said order dated 29/10/2025 was made available to the petitioner. And as such, the petitioner has been compelled to approach court. During the course of the hearing, Mr. M. Smith, the learned counsel, appearing on behalf of the respondent numbers 1 to 4, have provided a copy of the order dated 29/10/2025. So Mr. M. Smith further submits that the petitioner has an alternative remedy by filing an appeal with
Either section 45AA or section 75 before the EI court.
under section
45AA and section 75 of the
under sections 45AA
and section.
capital AA, read with section 75
Yes, madam.
of the ESI Act 1948. Taking into account that the petitioner has an alternative and efficacious remedy available under the provisions of the ESI Act 1948. And ESI Act 1948. as mentioned here in a, comma, it is the opinion of this court that the present, that this court is not inclined to entertain the present writ petition. Full stop. Next. As this court have, no, full stop. As this court have not entertained the instant writ petition on the ground that the petitioner has an alternative and efficacious remedy. And further, the petitioner, counsel for the petitioner has been served with a copy of the order dated 29/10/2025 only during the course of the hearing. This court grants, how much time is there?
Lordship, there is two provision. It's not read with 75. 75 and section 45 capital double A, two different appeals. So the 45 AA has 60 days.
And or queriable.
Yes, Lordship.
We put it as and oblique or.
Yes, Lordship. The 45 AA provides for 60 days limitation and 75 for 3 years. That would, I will have 45 AA has to be given a liberty by.
No, let us say 45A.
45 double A. Double A.
Itu besar, huh? During the course of the hearing, comma, this court directs that if the appeal is preferred within a period of 30 days.
Yes, Lordship.
From today, by the petitioner, the said appeal shall be taken up for, be decided on merits by the appellate authority without insisting on the question of limitation. Full stop.
Another appeal under section 45 AA may be mentioned, Manoj.
Appeal, that's it. An appeal is filed under section 45 AA. Within a period of 30 days from today, the said appeal be taken up without insisting on the question of limitation. This court further. So, before parting with the record, this court further makes it clear that the dismissal of the writ petition on being not entertained shall not prejudice the petitioner in the appeal proceeding, if so preferred, as directed above.
Highly obliged.
As observed. The order dated 29/10/2025 passed by the respondent number
Two. No. It is same person, name is the same person, Lordship, Samuel Nelson. Maybe designation of the designation changes.
Is the respondent number 3?
Not even.
But you have mentioned it, respondent number 3. Authorized, kept on record and marked with the letter X.
Highly obliged.
Yes, what do you do?
My lords, I'm for petitioner.
What remains in your proceedings?
My lords, I'm for petitioner. So I have taken a loan from the respondent bank, my lords. So my property is auctioned through DRT on 9/11/2023, my lord. So, my lord, I would request my lords to look at page number 42, my lords.
No. My question is,
Yes, my lords.
kindly come to the OTS.
OTS, yes, please, my lord.
In view of the OTS, what remains? You are to withdraw the writ petition.
Please, my lord, that is in clause 2 in the OTS, that is dated 11/8/2025, my lords. So to this effect, I have filed an additional affidavit, my lord, in which I have submitted the communication between the bank and myself, my lord.
Where is the OTS?
OTS is
201,
provided by
Your
the
Lord.
bank, my lord.
201.
Page 201.
Yes. In the affidavit filed by the auction purchaser.
Yes.
There are two.
11/8/2025, the payment schedule for rupees 40 lakhs will be as under. Date of payment on or before so and so, so and so. Have you made this payment?
Yes, Your Lordship.
Yes, my lords.
You have to withdraw the appeal case counterclaim filed against the bank at any forum, including writ petition filed in the writ petition.
Please, my lord.
Then,
My lords, here, I would prefer to, go from the beginning, my lord. I would not take more than 5 minutes of my lords. I would like to apprise the entire event, my lord. So here I am on, I have taken loan from the bank, my lord. And my property is auctioned through DRT on 9/11/2023, my lord. So my lords, I request my lords' attention to page number 42, my lords.
yes, what is this?
My lords, the order sheet dated 4/10/2023. It says, my lords, the nodal officer appeared for certificate holder bank, CHB for brevity, CD appeared in person. CHB has filed report that shows sale notice has been published in two newspapers on 24/8/2023, my lords. On 4/10/2023, one bid has been received for scheduled property A from the following bidder, whose name is Mr. K. Mohan Kumar, and subsequently his address is given, my lords. Now, my lords, I request my lords to look at page number 44.
So we say that the OTS is no longer there. Let them appropriate the 40 lakhs. And it will be, we will now follow as per clause 9, page 202. If there is no OTS, you go ahead, whatever you feel like. Because he does not accept this OTS, because OTS condition number 2 makes it very clear that he has to withdraw the writ petition.
Yes, sir.
If he wants to pursue the present writ petition, then the OTS is no longer there.
Yes.
That is fine, my lords. Please, my lord.
So now as we take it as if there is no OTS.
Okay. So that means I will be have an occasion to file my petition in DRT, my lord.
I'm not on that.
Yeah.
Whether you have a right or not, that's a different thing. So there's no OTS.
Please,
They recover whatever they want, they can.
Please, my
In
lord.
fact, on the last occasion, I am surprised that I didn't pass an interim order of extending. But how it was given, but there's so many matters, I find it out there. Anyways, I'll take it up with my stenographer.
My lords, I would pray
Now,
only.
my question is out here is what is your case? Let's see. What are you challenging here?
My
We
lords,
first record there is no OTS. Your case getting dismissed, you have a problem out here, then you have to take it up by yourself. Okay, now tell me what you are
Yes.
challenging which order?
my
Impugn
lord,
order dated 14/6/2000 passed by the DRT in IE number so and so, in accompanying number so and so, accompanying Iman, and the judgment dated so and so passed by DRT so and so. Okay, let us see 14/6/2024, page 106. This is an order passed by whom? The presiding officer.
Presiding officer, dear.
An appeal lies there against. So you have filed an appeal against the order passed by the learned, by the recovery officer.
yes, please, my lord.
And that recovery officer appeal was dismissed
Please,
on the ground that section 5 is not applicable.
please, my lord.
Okay, against that you filed an appeal.
In DRAT Kolkata, my lord.
DRAT you have filed an appeal. What has happened in the DRT?
To allow this prayer what is made, my lords, against proceeding of RO in DRT, my lord.
Now, how does section 14 come into the picture?
This is bona fide delay, my lords. Hence, I would like to apprise my lords from the beginning, my lord. I just need 5 minutes, not more than that.
No, my question is, how do you bring in section 14? Means there is a pendency of some proceedings somewhere.
Yes, this was in this honorable court, my lord. After that's why, my lord, I seek your
This court
permission.
is some order.
This court has passed an order.
Where is that order?
That is in page number 58, my lords. Dated 1/3/2024, my lords.
Now, when did you file the application under section 30?
That was filed after filing this.
When did you file that?
That is on 21/3/2024, my lord.
So it is within the time permitted by the High Court.
Yes, please, my lord.
But Mr. Counsel, tell me, when the
Please, ma'am.
petitioner seeks to withdraw,
Please, my lord.
not on the ground of the jurisdiction being not there,
Please, my lord.
or mentioning before this court
Please, my lord.
that the petitioner has been not properly exercising the jurisdiction in the right forum, or
Please.
there is an opinion to that effect,
Please, my lord.
do you get the benefit under section 14, more particularly taking into account section 12 of the Limitation Act?
Please, my lord.
Answer that.
Please,
This
my
is your simple case. Now I get it.
Yes.
The simple case is you initially moved this court against some order dated,
By
some
a-
order of dated 22/11/2023.
Please,
Some order passed by somebody, the recovery officer.
please, my lord.
The recovery officer, you got a stay on 22/11/2023.
Please, my lord.
And the court was this court was adjudicating the matter.
Please,
Now,
my lord.
if this court was adjudicating the matter, thereupon, at that point of time, the counsel appears on behalf of the petitioner and makes a submission before the court that he would like to withdraw and avail remedy before the DRT.
Please, my lord.
And the presiding officer, in view of section 30, if I am not wrong.
Please,
You
my lord.
therefore, thereupon you took the leave and the court granted the permission to you to move it.
Please, my lord.
Now, the moment the court granted the permission to move it,
Please, my lord.
unless and until it is being saved under section 14, which the court should have done.
Please, my lord, I understand, my lord.
Court should have mentioned it.
Please,
If the court have not mentioned it, can this court look into this? Wouldn't this court be going ahead? Because if you see the Limitation Act, how Limitation Act comes in. Limitation Act applies or not, it is another aspect.
please, my lord.
Just for example, if we see the judgment of a three judges bench of the Supreme Court, I think it was headed by Justice Gauhati. I remember this judgment where it is said that though in a writ proceedings,
Please, my lord.
the Limitation Act does not apply.
Please, my lord.
But then also, the benefit of the proceedings, because if you see section 14, section
Please.
14 mentions about the civil proceedings.
Please, my lord. Right.
And therefore, a writ proceedings would not come within the ambit of a civil proceeding. But that judgment makes it very clear that the benefit of the proceedings before the Supreme Court also, which was there,
Please, my
would
lord.
have been taken into consideration for the purpose of granting the benefit
Please, my lord.
under section 14. So therefore, can we hold it? Look into it. Kindly see section 12 of the Limitation Act.
May I help my lord?
In legal proceedings, you see, in computing the period of limitation for any suit, appeal, or application, the day from which such period is to be reckoned shall be excluded. In computing the period of limitation for an appeal or an application for leave, so and so, the day on which the judgment complained of or pronounced has to be where a decree or so and so, then exclusion of time in certain cases 15. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with a due diligence another civil proceeding, whether in a court of first instance or of an appeal or revision against the division, shall be excluded where the proceeding relate to the same matter in issue and executed in good faith in a court, which for defect of jurisdiction or causes of like nature is unable to entertain it.
Please, my lord. If my lord may permit, I would like to quote a case citation, my lord.
Okay. It's okay. I think you don't need to. We do one thing. We allow them to ask the DRT to take on record that.
Please, my lord.
Because here the court has passed that order.
Yes, sir.
They were even extending the in-time order to 22/11/2023.
Yes.
And he filed the application on 21/3/2024.
3/2024, my lord.
21/3/2024. Huh? You filed the application when?
Before one day of the cessation of this
one day.
honorable.
So therefore, this will be taken as a period within which the court had permitted. And accordingly, the DRT ought to have decided that without even looking into the question of section 5.
Please, my lord.
Your lordship.
And this will be, and the DRT shall consider as to whether the OTS has prevailed or not. You take it up. You want to reject the OTS, that is your lookout. In view of he pursuing with it. I'll record it that he wants to
right now I have closed everything. My position is that after getting his money of 40 lakhs, I have closed everything.
It's okay. Let him go. He's only against that order. You have got the money.
Yes.
You're happy.
It's auction money as well as the OTS money.
So you have got it. Now if he challenges, he gets an order, let him get. You fight it out there. Why should
we will fight it out? But what was happened? They have filed in section 5 application there.
Huh?
They have filed section 5 application before the
Section 5 was not necessary. The court having permitted him to approach there.
Yes.
And extending the period of limitation till 22, the period of the interim order till 22/3/2024, 2024, and 1 day prior to that he has filed it, it would be deemed that the court have exercised the jurisdiction under 14(2) and thereby granted him the leave, and that period during which the writ petition has been pending has to be excluded.
Please.
And whether it was done within 30 days. The writ petition was filed within 30 days or not?
Yes, please, my lord. That is filed within 5 days, my lord,
That
of
is
the recovery.
At page 56. the
Who are you?
Option purchaser.
Very well, purchase.
No, my lord, the interim order was not by staying the DRT orders. The interim was only in respect of registration of the same thing. By
Whatever may be, there was an interim order which was passed, which was extended. So therefore, the court would be deemed to have already got the benefit, extended it in terms with 14(2), and therefore he will be entitled to the benefit. And there is no requirement of filing a section 5. The section 5 which was filed as a matter of abandoned caution.
Please, my lord. Much obliged.
Heard Mr. So-and-so.
As per my calculation, my lord, the application, even otherwise, section 40, even then, my lord, it comes to 32 days.
Why?
Because, my lord, the impugn order was on 9th of 11/2023.
No, impugn order was passed on when?
9/11/23.
And then 23. And then
Then, my lord, the petition was filed on 20/11/23.
11 days, my lord.
11 days.
Yes, my lord. And thereafter, my lord, from 1st of to 22nd, because on
Huh?
from 1st March to 22nd of March, because the limitation that has been extended.
No, it will be taken from the date on which the writ petition was filed. The writ petition was filed in 11 days. And if we exclude this period till 22/3, then also he has another 11 days.
Please, my lord.
No, my lord, then 21 days comes in because, my lord, this limitation aspect, it did not stay the DRT order. Had there been a stay of the DRT order, that
Where is it mentioned that the DRT order has to be stayed?
In the
Page
impugned order,
56,
Your Honor.
page
In the impugned order.
I'm not on that. Has it not challenged the DRT order? The DRT recovery officer's order is when? Dated?
9/11/23.
9/11/2022.
23,
Your Honor.
23. By writ petition filed on
2011/23.
2011/2023. Interim order passed on 22/11/2023. He had taken the AR on 1/3/2024. Filed the petition on 21.
22/3/2024.
No, I filed the
21.
21/3/2020.
It's 20.
Okay, 22/3/2024.
4.
So the court having extended the interim order till so and so, the court have given it. You ought to have challenged this order. Anyways, heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. Mr.
Prashanta.
Give your name. Mr. M. Sharma appears on behalf of the respondent numbers 1 and 2.
Yes, sir.
You are appearing for
3, my lord.
respondent number 3. Who is 4?
4 is the option purchaser of the another property, but they have not challenged.
They have not checked. Okay. Appears for respondent number 3. None appears on behalf of the respondent number 4 and 5. The present writ petition has been filed challenging the order dated 14/6/2025, 14/6/2024, passed by the DRT Gauhati in IA 210/2024, as well as the judgment dated 22/4/2025, passed by the DRAT Kolkata in appeal number 106/2024. Full stop. At the outset, it is pertinent to take note of that pertinent to take note of. Annexure 9 series to the affidavit in opposition filed by the Canara Bank.
No, respondent number 3 has filed. We have not filed.
Okay. Annexure 9 series to the affidavit filed by the respondent number 3, wherein it is seen that the petitioner herein was granted an one-time settlement OTS for rupees 40 lakhs subject to the terms and conditions mentioned in the said document dated 11/8/2025. It included, amongst the various terms and conditions, it included the term that the petitioner would withdraw appeal, oblique case, oblique claim, oblique counterclaim filed against the Canara Bank at any forum, including the present writ petition filed The petitioner was also required to withdraw the cases filed against the other bank officials at any forum related to the said account. Mr. M. Sharma, the learned counsel appearing on behalf of the Canara Bank, submitted that that the petitioner had duly accepted the OTS and therefore the present proceedings could not be proceeded with. On the other hand, Mr. So-and-so, who represents the petitioner, refers to the additional affidavit filed on 17th of July 2026. Wherein it is mentioned that immediately after remittance of the OTS amount of rupees 40 lakhs, the petitioner via an email dated 22/8/2025 to the respondent number 1 had categorically mentioned about the petitioner's acceptance of the OTS along with a request to the respondent number 1 to appropriate the remitted amounts towards the OTS and issue the no due certificate and the loan closure certificate and return the original title deeds. It was further mentioned that in the email, the writ proceedings against the bank would be withdrawn upon implementation of the OTS, while the proceedings against the respondent number 3 would continue independently. However, the respondent number 1 have not sent any reply disputing or denying the contents of the email. But Mr. Counsel, in view of this, how can you proceed now?
My lords, please, my lords. So That is where I was coming from, my lord. This entire sale, what they have made is actually a fraud, my lord. That is what, it's a fraudulent sale, my lord. That's why I requested my lords to look at page number 42 and 44, wherein on page number 42, it clearly says that there's only one bidder on the final date of the bid, which who is K. Mohan Kumar, my lords. On the next hearing, that is 9/10/2023, in page number 44, suddenly there is one Sri H.G. Lokesh Murthy comes in.
Okay.
So there is no explanation for that, my lord. There is no bidder registration provided, whether he has provided the EMD or not. No details are provided, my lord. Here it says Mohan Kumar, and suddenly Lokesh Murthy comes. So this is what I want to question, my lord. Assuming, my lord, even for a sake of discussion, I have signed this OTS, my lord. Bank
You have
cannot.
not only signed the OTS, you have on affidavit stated that you have accepted the OTS.
Not on.
And you would not like to pursue against the bank. Then how can this court now, in view of that affidavit, provide you the remedies?
No, my lord, in the affidavit, I have said that I have sent them a mail stating that this proceedings will continue. my
No.
lords. Yes, my lord.
No, kindly see paragraph 4. Paragraph 4 sees paragraph 4.
209, my lords.
Mentioned about the petitioner's acceptance of the OTS, along with a request to the respondent to appropriate the remitted amount towards the OTS and issue the no due certificate. The email further states that the writ proceeding against them would be withdrawn upon implementation of the OTS.
Please.
While the proceedings against so and so would continue independently. That is a different proceedings.
My lord, that may be a technical
No,
error
no, Mr.
wording.
Counsel.
My lord, it also reads.
No.
Please, my lord.
Petitions has been
Stop. Taking into account the stand which has been taken. No, Mr. Counsel.
Please, my lord.
No, sorry.
I request for
Taking
only
into
one.
account the stand which has been taken in
Please,
the
my
affidavit, more particularly at paragraph number 4 and 5. Additional affidavit, more particularly at paragraph number 4 and 5. At 5 of the additional affidavit.
Please,
dated
my lord.
17/7/2026.
I beg my lord's
which he
pardon,
kept on
my lord.
record and marked with the letter X, comma. The present petitioner cannot proceed with the present writ petition, for which the writ petition stands dismissed.
Please, my lord. My lord, if we continue, my lord, the same statement I have mentioned, my lord, it is pertinent to mention here that although the instant case is initiated by the petitioner before the honorable court.
The dismissal of the instant writ petition, however, shall not preclude the petitioner to avail remedies against the respondent number 3 if so advised.
My
That
lord.
is what you asked.
Please, ma'am.
Interim orders partially stands vacant.
Your lordship, order has been complied with.
Complied?
Yes, your lordship. And you may, because what was happened.
Finally complied. M. Sharma, the learned counsel, appearing on behalf of the petition, respondent numbers 1 and 2, submits that the order dated 1/4/2026 in WPC number 1882/2026 have been duly complied with. Mr. So-and-so also submits that it has been complied with. Taking into account the above, nothing further remains in the instant proceedings for which the contempt proceeding stands strong.
Diplo.
My lord, in this matter, the petitioner is challenging an order dated 3/6/2026 passed by the GMC wherein the premises of the petitioner have been sealed, your lordship.
Huh?
where the premises of the petitioner was sealed without following the procedure laid down under section 404.
Therefore, the draft and the order for desealing, that has been done.
Yes, yes, that has been done.
Desealing done.
Done.
Desealing done.
Mr. Esbora, the learned counsel appearing on behalf of the petitioner submits that pursuant to the order passed by this court on 4/6/2026, the petitioner's premises have been desealed. Full stop. And so he further submits upon instructions that if any action is required, further action is required to be taken, the same would be taken by following the provisions of section 404(3) of the Gauhati Municipal Corporation Act 1969. Taking into account the above, nothing further remains in the instant proceedings for which the writ petition stands clear. Obliged.
My lord, I am sorry, but in the last lodging court order, I missed, my lord. So I may be allowed to take a fresh steps upon it 5, 6, and 7. So the difficulty is, my lord, here also. So far, the respondent number 5 is there. So he is already been transferred. So not able to gather his recent address. So direction may be given to through the superintendent of police Tezpur that may be served, my lord. That is the last order, but is, my lord, this is 16/7, my lord. Lodging.
Now, what has happened pursuant to the notice being issued?
My lord, which one, my lord?
Notice being issued in these proceedings in
Yes.
2018, what
Yes.
has happened?
My lord, now my instruction is, whatever, my lord, the revision petition was there, that has been in my favor already come, my lord.
So matters
But
nothing
not,
remains.
not only, my lord, because we are.
No, you have an order of injunction passed by some order being passed
By the
sessions court.
Yes, my lord.
Now, if the session court and not to arrest or harass the petitioner without following the due process, why should this court and then entertain this time?
No,
You are
my lord,
asking
the
for
allegation is this, my lord, during the, no,
nothing
kindly,
being-
kindly, my lord.
No, Mr.
No, no,
Sorry.
no, kindly
This
see,
type
my,
of- no,
kindly.
Mr. D'Souza, Mr.
my lord, my
Mr.
lord, my lord.
Mohanta, these type of cases cannot remain.
No, my lord, kindly see, my lord, one thing, my lord, kindly, my lord, annexer 2, my lord. Kindly see, my lord, annexer 2. At page,
From the
it is
petitioner,
23, my lord.
so and so, thereafter the petitioner.
Is it a procedure, my
the
lord?
land so and so. Considering the fact the circle officer so and so hereby to remain present to maintain law and order during the time of construction of the southern boundary wall. Now, what is there?
Then, my lord, in by this order, my lord, the
So
police
you
and
take the power
all
to
personnel
discuss
enter my land.
the order contained in so and so passed by the additional district magistrate Punitpur.
But there is no basis on what basis, my lord, what pieces they have filed. The district,
Appears
additional
that the
district
revision
magistrate,
is
my lord,
already
without any
according
following the
to
procedure, pass this order. Against that order, we have come. So now they're exercising this order, they have entered my land and forcefully, we were already been driven out.
Now, your revision has been allowed?
My revision has been allowed, but the action, I against the illegal action of the police, my lord. But during that time, my lord, their exercise was totally illegal because the exercise, whatever has been initiated from the additional district magistrate, that is also not legal, my lord. But at least, my lord, some procedure should be there. However, my lord, we have been interfered, police protection has been given.
Mr. Mohanta, better things to do on a better day, on a better case, not to this.
No, my lord, only, my lord, my.
Division bench. Heard Mr.
No, I am not going to bed division. Whatever will be there, loss I will apply. But one thing, my lord, kindly, my lord.
So and so appear, no, nothing.
My lord, the
Mr.
action,
P.
whatever is
Mohanta-
there, but it is always there. If it is not giving the, my lord, protection, just encourage to be there, my lord. They are always coming in that way.
1, 2, and 3. Full stop. The present writ petition has been filed by the petitioner seeking a direction upon the police authorities, more particularly the respondent number 4 and 5, not to interfere with the peaceful possession of the petitioners, land being protected by order dated 11/4/2018, passed by the learned session judge Punitpur Tejpur in criminal revision number 14 bracket S-2 bracket oblique 2018, and not to arrest or harass the petitioner without following the procedure of law. The record reveals that an order was passed on 4/4/2018 by the additional district magistrate Hunitpur. Wherein it is mentioned that as per the report of the circle officer, Tezpur Revenue Circle, the land in question was under the physical possession of one of Sri Satpal Tayal and Rajesh Tayal, and the opposite parties were forcefully obstructing in constructing the southern boundary wall without any locus standi. It was further mentioned in the order dated 4/4/2018 that the circle officer, Tezpur Revenue Circle, as well as the executive magistrate should be present to maintain law and order during the time of construction of the said southern boundary wall with the help of the police personnel. The petitioner, being aggrieved, preferred a revision application before the learned Session Judge Hunitpur, Tezpur, which was registered and numbered as Criminal Revision Case Number 14 bracket S-2 bracket close of 2018. An order was passed on 11/4/2017. Our revision is registered in 18, order passed on 2000.
No, but this is my lord, I have stated my lord, these are wrongly my lord quoted my lord, that should have been 18 my lord.
An order was passed on 11/4/2018 bracket wrongly shown in the order as 11/4/2017.
Signature is 18 my lord.
Whereby the revision was admitted and the order dated 4/4/2018 issued by the learned ADM Hunitpur Tezpur was stayed until further orders. It is the further case of the petitioners that in spite of the said orders, the respondent authorities, and more particularly the respondent numbers 4 and 5, were taking action against the petitioners, and as such have sought for the direction relief as already mentioned here in above. Footstop. The record reveals that when the writ petition was filed on P5/2018, the learned coordinate bench of this court merely issued notice. Footstop. After issuance of notice, till date, the petitioner have not been able to effect service upon the respondents, the
5, 6, 7.
the private respondents. Footstop. Mr. P. Mohanta, the learned sub counsel appearing on behalf of the petitioner, submits that in the meantime, the order dated 4/4/2018 passed by the ADM Hunitpur have been set aside. Set. You have the order copy?
My lord, order copy I am not there, but I got it as information that it has been in
Submits that to his information, the order dated 4/4/2018 passed in ADM by the ADM Hunitpur Tezpur have been set aside. Full stop. Taking into account the above, it is the opinion of this court then nothing further that this court further takes note of that the dispute between the petitioner and the respondent number 6 and 7 are purely civil disputes as regards the possession of the land or a civil dispute as regards the boundary, as regards the b- which are purely boundary disputes. The continuation of the instant proceedings. The continuation, under such circumstances, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed.
My lord, I may pray one correction, my lord. But the failure of the part of me is, my lord, not that I could not serve. My lord, in spite of serving, taking steps, my lord, it going.
Tell
the
me
distance,
whether,
my lord.
no, tell me whether respond number 4 and 5 are still there in Tezpur.
The 4 was served, my lord. The 5, my lord.
My question is whether respond number 4 and 5 are still there in the Tezpur.
4 is I am not aware, but the 5 is already transferred out, my lord. So, my lord, I
In
have taken
addition
step,
to
my lord.
that, the respondent number 4 and 5 is no longer is the even
Bas.
May I please, your lordship?
Yes, what is your
My lord,
matter?
this is regarding, my lord, a claim, my lord, for compensation of victim compensation, my lord, under victim compensation scheme 2012, my lord. The petitioner's father, my lord, was murdered and judgment has given, but learned trial court, my lord, did not recommend for compensation, my lord. Yes, my lord, 20, my lord. This is the notification, kindly see.
No, no, here the learned here recommended lesser amount.
No, my lord, not at all.
She entered appearance on behalf of the respondent and as such required time. Yes, what happened?
My lord, judgment was given, my lord. Trial took place, judgment was delivered, but my lord, no recommendation was made by the trial court, my lord.
Why?
That is best known to the learned.
No, whether it is recommendation or not, what is this?
Judgment, my lord, kindly see page, my lord, 26, my lord, judgment.
You are appealing for whom?
My father, my lord.
Huh?
I am the son. I am son and
You require that money.
yes, my lord.
As on how much? 2
Five,
lakhs.
5 lakhs, my lord. Earlier it was 2 lakhs, my lord. Then it was enhanced, my lord, by notification 2019, where it was revised, my lord.
Where?
Page 24, my lord.
Debt? Where debt is 4 lakhs, 5 lakhs, where?
5 lakhs, page 24, my lord. Serial number 6, my lord.
6. Debt.
My lord.
Okay.
Minimum.
So your father died
Father died, my lord.
on account of a crime,
Crime, my lord.
but nobody was found out.
Nobody, yes, my lord. Dead body was traced out. Trial took place, but nobody was, my lord. And so case ended in acquittal.
Dead body was traced out.
My lord.
There is a judgment of Justice Bhuiya on this, that a crime have been committed.
Yes, my lord. I have annexed here, my lord. Similar order page 34 starts from 34. Relevant page 43, my lord.
Therefore, here it says, being the position is so and so, he is directed to claim that amount.
And your lordship also passed an order.
Where is that?
But that was disposed of on motion stage, my lord.
And, this should have been disposed of in the motion itself.
But in my case, my lord, in between during pendency, they have rejected, my lord. In that case, rejection order was not there.
That's not condensed. The order was already passed prior to prior to the fact that he has come to.
But that was not communicated. How I will know?
Not during pendency.
I mentioned that is a case where a crime was committed and as a result of the crime, the petitioner's father lost his life. It is another matter that in the trial that ensured the accused persons were acquitted. But that does not in any manner negate the factor of the crime of commission of the crime or the resulting loss or injury suffered by so and so. So we can pass the same order.
Same. Only here, my lord.
Instead that 4 months.
a delay of 4 years in approaching the LSA.
The delay, this is welfare legislation.
No, that is not applicable in my case. That is subsection 3 of rule, in section 357A, my lord, where trial, no trial takes place. Then limitation is applicable, my lord. But in my case, trial has taken place. Page 12, my lord, of my pleading.
When did you apply?
I applied my
Been
on,
delivered on 2015.
yes, my lord.
When did you apply?
I applied on 21st-10-2019, my lord.
4 years.
And in between, my lord, I approached also, my lord.
Huh?
Petitioner requested, my lord. Mother of the petitioner requested. And my lord, that is another thing, my lord, because that was an allegation. Page 21 of the notification, my lord. Delay, my lord, that is not applicable in my case.
You say 357A4.
A4 is not in my case. 3 will be, my lord. Because here trial takes place.
Where? A4 is where? do I
Page
get
12
it?
of my,
Where the offender is not traced or identified, but the victim is identified where no trial takes place, the victim or his or her may make an application for it. এইখনৰ মতে চাই পেলাই দি দিব এইটো আগৰ ফেক্স খিনি বদলাই দিব so and so here the case of the petitioner is that এইটো আগৰ খিনি পাই যাব trialত এয়া হ'ল acquittal হ'ল however there was no direction in the seizure for payment so and so draws the attention to so and so commit that so and so iman Hello, এখন draft করো on the basis of this rules.
deeply obliged, my lord.
Amount to be paid within 6 months.
Deeply obliged, my lord.
আর মোৰ আৰু order আছে চাই লওঁ। Item 19, what is this?
Lord, this case unfolds a story of administrative excesses committed by the administrative authorities by bulldozing a part of my residential house
For the left,
without notice, without anything. So,
what is their stand?
they say that they wanted that some public complaints were there that some people have encroached upon the roadside land and drains are not working well, and therefore they undertook this. Give me this affidavit. They submitted an affidavit.
Where did this land happen? This land is where?
Land is in Lanka. Lanka, I constructed my house in 1970. That time, Lanka was a rural area. Town committee came in 75. And district was declared in 15. In 2017, suddenly one fine morning, they appeared before my house and bulldozed a part of it. Without any notice, without any intimation to me. I rushed to this honorable court. This court protected that don't go further. But they have raised it in the meanwhile. Now they are coming. It is my
What
paternal
has
land.
happened?
Sorry.
Now what has happened?
Now it is in that stage. They didn't proceed further. Photograph Lordship may see. My half was demolished and I have subsequently just make it habitable at page 27. Lordship will
Was
find.
your house situated within your land?
Sorry?
Was the house situated within your land?
Yes, yes. This is my case, my patta land. They could not have done it. Could not have done it. And kindly see, they didn't issue any notice to me. Had there been a notice, I could have shown them. They could have taken a hearing, Lordship's judgment, 18.2. Even if in 18.2 also they are bound to follow.
Judgment came later on. Na?
Well, true. Supreme Court decision has also come later on. 25. But meanwhile, this is how the injustice is done. Nobody was there to listen to me. Even when I protested, why are you doing it? They have arrested me, my 75 at that time, the father and the 3 sons were taken and put in Hazur. That was the situation. And after 3 days, after 1 day, father was released. After 3-4 days, bail was granted to the sons. That was the situation. The father has meanwhile died. So, sons have been implemented here. What is?
Now, what do you want to do?
I want that adequate compensation should be there and accountability should be fixed. How can they do like this? Accountability should be fixed so that in future they cannot do like this. Lordship will appreciate. Even for argument's sake, they claim that I was occupying some roadside.
Mr. Counsel, why are you not filing a reply to those affidavits?
Well, these sons now subsequently pleaded. They are scared of coming and going ahead further.
Then how do I proceed with it?
Well,
Because
that,
you see,
not,
that is why I saw the affidavit of the respondent number 2.
Yes.
Without there being a reply to these comments,
yes,
becomes very difficult. Otherwise, there will be a deemed admission on your part.
not
Yes,
exactly.
there is
But
no
I
doubt,
appreciate.
No doubt, no notice was issued.
Yes.
But fact remains that at that point of time, that was how, till Salakuddin's judgment came in, there was always a no notice.
Yes.
There are many judgments passed by learned coordinate benches wherein says no notice is required. It is because of that the reference happened.
Yes, yes.
At that point of time, the law was like that. No notice. Although it should have been a notice,
Yeah,
but there was no notice.
Not that no notice was required under the law, it was. But that was not followed. That was not
No,
enforced.
But the coordinate benches have duly accepted that no notice is
In
required.
certain facts, true. In certain facts, true. But ultimately, that has been corrected. That probably that was not the correct law. That was not the correct law. And here, my lord, why I am saying that even without
No,
the
you may very
redundant-
well argue that when the division bench held it, that a notice was required.
Yes.
It dates back to the date on which 18.2 came into being. Because our orders will have an impact from the date on which the law came into force.
Yes.
But at that point of time, the law was otherwise.
Law was same.
So
Interpretation was
for imposition of a compensation to them,
yes.
when the law was held by the coordinate benches to the effect that no notice is required, would it be proper?
My lord, factually, in case-wise, that law will not apply. My respectful assumption is this.
But that was because at that point of time, the single benches held so.
18.2 in respect of 18.2. My lord, true, they are in their affidavit, they have taken the plea that 18.2 we have done it. But is it a case for 18.2 even? I will go to that also. I am there since 1970, concrete buildings were there. Even if I am occupying for argument's sake the government land, I am liable under 18.3 notice must be there, hearing must be given. Lordship is aware about that law.
No, the moment the land they are saying to be a land which is reserved for footpath,
yes,
then it would be outside 18.3, it will come under 18.2.
No, my lord. Here, had it been appropriately, exactly on the road itself.
No, which is reserved for footpath.
I see that is to be found out. There needs an inquiry that yes, you are occupying this. You vacate it, else we will demolish it. That was the law that time also prevailing. I agree that in some cases there may be some encroachment.
Whatever may be, Mr. Mohandas, the fact remains that you have not submitted your reply.
I can make a last attempt, my lord, after asking them to come forward and file the
Because
reply.
without making that reply, it becomes very difficult.
And that of course would make it convenient for this honorable court and
No, you
in the
you
law.
want a constitutional thought. So a constitutional thought has to be adjudicated on the basis of the touchstones of many aspects.
Yes,
As
yes.
to can you hold these persons responsible when the law otherwise was like this? Now, whether a notice, without a notice, because you see, after that judgment in of the Supreme Court in 1997, they made an amendment in the year 1997, bringing in everything under the sky which belongs to the government within the
Yes.
ambit of 18.2.
Yes.
So therefore, at that point of time, everything could have been done under 18.2, and the courts were holding that no notice is required. So therefore, the fact on the basis of that not no notice, but if there is something more than that. Now, kindly look into another judgment. Now you have the judgment pertaining to the bulldozer, which is given by Justice Gavai.
Gavai.
Just, I think 15 days before, there is another judgment, which is also equally important. Is a three judges judgment. I think that is a judgment written by Justice Chandrasud before he demitted his office. Look into that, where 25 lakhs were imposed. Have a look into that. That
I'll
may
see.
help you out. But otherwise, without a reply, you
I'll
have
see
a
to
bad
that
case.
also. I'll see to that also. I'll see to that also. They have to be encouraged to come forward and fight it.
I think we
This
cannot
is how
proceed.
father has died. They're scared of that now at this stage.
And we fix the matter immediately because it's almost
Lordship
a
will-
decade old.
Lordship may also keep it as partner. I will
No,
see.
why? No, partner, no.
But
Okay.
so
List this matter
expeditiously.
again. I was. It is Mr. Mohanto, the learned counsel, senior counsel appearing on behalf of the petitioner, submits that that he would that taking into account those allegations which are made in the affidavits, the averments made in the affidavit filed by the respondent number 2 and 7, the petitioner would be well advised to file a reply. Taking into account, this court also takes note of that the instant repetition is almost a decade old. Accordingly, list this matter on 21st of August 2026. A final opportunity is being granted to the petitioners to bring on record their reply to the affidavits filed. Reply to the affidavit filed by the respondent number 2 and 7.
Obliged.
This, my lord, in item 21, I am appearing for the petitioner, and in 20, I am for the respondent, private respondent, my lord. So basically, my case is that this petitioner's company, she had taken a loan from this respondent bank in the year 1994 and 95. Thereafter, a fire was broke out in the factory, my lord. Then in the year 2016, OTS was happened. So we have accepted the OTS, and one time settlement was done, and we have paid the settlement also. So thereafter, they are not returning our original documents, my lord. That is the case, my lord.
In item number
21, my lord.
21 is what item?
Writ petition
WBC
3110.
They are not returning the original document.
Yes, my lord.
And who appears for in the Utpal Kakoti?
It's another petition, council, my lord.
Now, what is that matter about? Any idea?
Similar matter. He was the managing director. Earlier, he had filed the petition, my lord. So thereafter, recently, in our case, my lord, basically their stand is that we didn't submit the original documents. So therefore they are not returning it. So in my petition, the impugn order is at page 70. They have a contradictory stand, my lord. So it was in my name, therefore I have to approach before this honorable court.
So 20 is different.
20, the cause of, it is the cause of action and the matter is same, my lord. The person is different. He was the managing director and I'm the director of that company.
No. Pinapani Das Kakoti is who?
She is the director of that company.
Of the particular company?
Yes.
And
And
Utpal Kakoti
He,
is
he,
also
he was the managing director of that company.
at that point of time.
Yes.
So same cause of action, two requisitions,
Yes, my lord.
asking the same.
Exactly same, my lord. Almost same.
So what remains in 20?
My lord,
What remains in 20 then? When into 2026, another requisition is being.
my lord, because this impugn order has been passed in the year 2024, 2024 in my name as a director. And
So
I,
initially, so you mean to say the
and
first,
as I,
the managing director of the company filed a requisition
yes,
seeking for the original documents.
yes.
When that requisition was filed pending disposal, during the pendency of that
Yes.
requisition, some order was passed.
Yes.
That order has been put to challenge in the second requisition.
No, my lord. That order has not been challenged in the second petition. The order challenged in the second writ petition is 6/9/2024. That is another. And in that loan, my lord, we have mortgaged 3 properties. And among the 3 properties, one property is in my name. I am the registered owner of that property, and I am just only asking for the land documents only for that particular property, my lord. And that managing director is asking for the another properties also.
So the cause of action will
Cause
be
of action
different.
is same.
No, it will be different. If the
Fact,
property
facts,
is
facts are same. Cause of actions are different. Yes, my lord.
obviously the
Yes,
cause of
yes.
action is different. One is a different property, one is a
Yes,
different property.
yes.
Okay. And what is your stand, Mr. Counsel?
In item 20, my lord, the older writ petition, there the categorical stand has been taken that no original deeds were submitted. Only, my lord, Xerox photocopies. So the petitioner, Utpal Kakoti, was given a medium-term loan. Medium-term loan was given only based on the photocopy document.
How is it? How do you say so?
In our affidavit, my lord, we have made that contention.
No, you have created mortgage, equitable mortgage on deposit of title deeds.
Yes.
We have created equitable mortgage on deposit of title deeds in the charge document. Because you are a bank, you have to file your charge document. Are you not therefore mentioning what are the documents you are having?
Yes,
You
sir.
mention in the charge document that you are having a photocopy. How can it be possible? You do not grant any loan unless your bank is something else.
But that is the stand, my lord, taken in the.
Cannot be. Where's the charge document? Okay, taking into account that the counsel for the petitioner in WPC number 1179/2020 is not present. The matter stands adjourned to be listed again on 7th of September 2026. Itu 20th order দিব. Now come to 21. Okay.
My lord, the OTS was done on, my lord will please to find that.
No,
page fif-
first of all, when the charge was made, you were granted a loan.
Yes.
Loan against what?
Loan against 3 properties.
Which are where is the document?
That is mentioned at page number 35, my lord. That is the type copy, security.
Yes. Stock of raw materials and finished product out. Land measuring so and so.
Third paragraph from bottom, my lord. That is my concerned land.
Land measuring 1 katha
1 katha 6 lesses.
Covered by so and so. This was the security.
Yes.
Now the security is being created on what basis?
On a sale deed, my lord.
Now how do you show that? The deposit of sale deed of what? There will be an acknowledgement to that effect. Where's the deposit of sale deed?
My lord, there was no acknowledgement. Basically,
Where is the acknowledgement?
there was no acknowledgement.
No, because it is always written.
Yes.
When the loan is being provided, it is always mentioned about the deposit of sale deed.
Yes.
It is not mentioned anywhere.
Yes, my lord. But at page 70, they have stated, my lord, the impugn order, the last page, my lord. Second paragraph, the bank will return the original land documents submitted while availing the empty loan and the cash credit loan account subject to the recovery of dues and withdrawal of court cases. They have threatened like that. Withdrawal of court cases filed before the Honorable High Court under WBC number 1179 of 2020 and other cases filed.
Then why have you written this?
I would like to take instructions on this letter specifically. I will do.
Whose affidavit is this?
No, it's not affidavit, my lord.
It is.
It is in my writ petition.
The second one.
দুইটাতে এটা already. Both the writ petitions are interconnected. The Assam Cooperatives Apex Bank Limited provided provided to a company facilities of a medium-term loan as well as cash credit account provided to a company, namely MS Jayashree Mine Products Private Limited, a medium-term loan as well as cash credit account. It is the specific case of the petitioners in both the writ petitions that for availing the medium-term loan as well as the cash credit account facilities, they had deposited the title deeds.
Yes.
The then managing director of the company, namely Jayashree Mine Products Limited, had filed a writ petition, had filed WPC number 1179 of 2020. Claiming that the said amount that in view of the OTS settlement and the payment so made,
Yes.
the Assam Cooperative Apex Bank Limited should return the original deeds. A stand has been taken by the Assam Cooperative Apex Bank Limited that the original deeds were not submitted. This court finds it very surprising. This court finds it astonishing to take note of the said stand in view of the fact that it is the normal practice that an equitable mortgage by deposit of title deeds can only be granted when the original title deed is submitted. This court also finds it relevant to take note of that on 6/9/2024, the general manager of the Assam Cooperative Apex Bank have written a letter to the petitioner in WPC number 3110/2026, stating inter alia that upon payment of the outstanding amount of rupees 24,85,244.50 lying in the books against the company, namely Jayashree Mine Products Limited, the original land document submitted while availing the medium-term loan as well as the cash credit account would be returned subject to withdrawal of the court case being WPC number 1179/2020. The said communication, which is annexure 18 to WPC number 3110/2026, belies the stand of the Apex Cooperative Assam Cooperative Apex Bank Limited as stated in the affidavit in opposition. Mr. I. Botaku, the learned counsel appearing on behalf of the Assam Cooperative Apex Bank Limited, submits that he would obtain instructions and file an affidavit in that regard. This matter again on 26th of August 2026. The affidavit be filed on or before 21st of August 2026. So further, taking into account that one of the writ petitions is pending since the year 2020, this opportunity so granted as to be is the final opportunity.
Much obliged, my lord.
I have received instruction, my lord. We have admitted the liability of 5,93,942, my lord. I have the instruction.
Yes,
My lord,
Mr. S. Dotto.
this is my instruction. Yes. Overall. Yes.
I asked for an up-to-date instruction.
Lordship, yesterday we have sent a proposal to the government.
So you admit to that.
Lordship,
So you have proposal to the government for making payment.
Lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss Anbora appears on behalf of the respondent numbers 1, 2,
1, 2.
Miss Udas, the learned additional senior government advocate, appears on behalf of the respondent number 3 and 4. The petitioner herein being aggrieved by the inaction on the part of the respondent authorities not to release an amount of rupees 5,93,942 has approached this court by filing the present petition. The record reveals that on 13/5/2026, when the writ petition was taken up, the district commissioner in charge Lakhimpur, by the communication dated 24/4/2026, categorically admitted that the petitioner was entitled to the amount of rupees 5,93,942. And this aspect was duly recorded in the order dated 13/5/2026. And the document which was placed have been kept on record and marked with the letter Y. In the order dated 13/5/2026, this court sought for instructions from the PNRD department as to why the petitioner had not been paid the outstanding dues. Today, when the matter is being taken up, Ms. N. Bora, the learned counsel appearing on behalf standing counsel of the PNRD, submits that the PNRD also duly admits the said amount, inasmuch as the Commissioner PNRD had written a letter to the Additional Chief Secretary to the Government of Assam PNRD on 23/7/2026 for providing financial sanction to the amount of rupees 5,93,942, which is payable to the petitioner. The said document is kept on record and marked with the letter Z. Further to that, it is also seen that on the same date, a justification note have also been placed before the Senior Financial Advisor, Panchayat and Rural Development Department, PNRD, and as well as the Additional Chief Secretary, PNRD, that the amount pertaining to the amount of rupees 5,93,942 be incorporated in the budget, in the 2026-27 budget, and sanctions be accorded during the financial year 2026-27. The said document is also kept on record and marked with the letter Z1. In view of the categorical admission on the part of the respondent authorities that the petitioner is entitled to the amount of rupees 5,93,942, it is the opinion of this court that the petitioner is entitled to certain directions for the release and disbursal of the said amount of rupees 5,93,942. Accordingly, the writ petition stands disposed of with the following observations and directions. The respondent number numbers 1 and 2 are directed to forthwith transfer the amount of rupees 5,93,942 to the District Commissioner Lakhimpur. The District Commissioner Lakhimpur thereupon, upon receipt, the District Commissioner number 2, upon receipt of the said amount, shall disburse the amount to the petitioner. The said exercise be completed within a period of 3 months from today. What is your instructions?
Lordship, I think it can be disposed of on the basis of this instance. The earlier recommendation was of 2017. It was not recommended, Lordship. Thereafter, it will be placed before the next SDLAC on the report submitted by the present circle officer, Lordship. But that cannot be done because of next page is the report of the circle officer. নাই এটাই কৰি দিব লাগে মোৰ লগত নাই মই এতিয়া মন কৰিছো
Mr. H. Sharma, the learned counsel appearing on behalf of the petitioner. Our respondent numbers
1, 3, 4, 5, and 6. State respondent.
have placed an instruction issued by the Additional District Commissioner Dhubri, which is kept on record and marked with the letter X. From a perusal of the said report, it is seen that upon the spot verification, upon receipt of the spot verification report from the concerned from the circle officer Agomoni Revenue Circle, the proposal for allotment of the land would be submitted to the SDLAC. It is also seen from the said instructions that on account of the incessant rains, the said the possession report could not be prepared. Considering the above, list this matter on 18th of September 2026 for an update. I keep it pending, otherwise you would never get.
Lordship,
the
Lordship. May I get back that report, Lordship?
No.
Lordship,
This is kept
then
on
I will
record.
make a copy, Lordship. Only one copy is there, Lordship. I will make a copy.
Lordship, I pray for some time to file reply in this case, Lordship.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the respondent number 2 had filed an affidavit in opposition on 18/7/2026. And the petitioner would like to file a reply. Oh, what is this? You are running a coal plant on a coke plant on a government land?
Lordship.
You do one thing. Where is the notice?
Page 55, Lordship.
Page
55.
55. Your only thing is that you were not issued a notice.
Yes, Lord.
Okay, this order shall be construed to be the notice. You file your reply within 15 days, they will consider and dispose it of. Why should we look into it?
Lordship.
Unnecessary. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S. Dutta appears on behalf of the respondent number 1. Mr. H. Sharma appears for the respondent number 2, 3, and 4. The petitioner herein, who is engaged in the business of manufacturing coal in the name and style of DGP coal, coke coal, is aggrieved by the order dated 19/10/2023, whereby the petitioner was informed that the petitioner has to vacate within 15 days, failing which the petitioner would be evicted from the land wherein he has set up his coke plant. Full stop. The only grievance for against the only grievance of the petitioner in the instant proceedings is that the said impugned order dated 19/10/2023 was issued without providing the petitioner an opportunity of hearing, without issuing the petitioner a show cause notice, so that the petitioner could have made appropriate representation, thereby claiming that the petitioner has a bona fide claim of right to remain in possession of the government land. Taking into account the limited grievance of the petitioner, this court is of the opinion that the dispute in the instant proceedings can be taking into account the limited grievance of the petitioner. This court disposes of the instant petition with the following observations and directions. Number one, the order dated 19/10/2023 be construed as a show cause notice to the petitioner under Rule 18(2) of the settlement rules as framed under the Assam Land and Revenue Regulation 1886. Number two, the petitioner is granted 30 days time from today for submitting a representation before the subdivisional magistrate, subdivisional officer, civil Margarita, placing the necessary documents to show that the petitioner has a right to remain in possession over the land which admittedly belongs to the government. Number three, upon submission of the said representation, the subdivisional officer civil shall provide an opportunity of hearing to the petitioner and thereupon decide the representation so submitted by the petitioner as per the liberty granted herein above. Full stop. On the basis of the such decision, the subdivisional officer civil, Margarita, shall take such action as permissible under law. This court further makes it clear that for a period of 30 days from the date of such decision taken on the representation of the petitioner, further observes that if the decision so taken upon the representation is against the petitioner, no action shall be taken for a period of 30 days from the date of the decision, thereby providing the petitioner an opportunity to avail remedies as permissible under the law. This court further makes it clear that during this period, till the expiry of the period of 30 days from the date of such decision, if against the petitioner, no action for eviction of the petitioner be carried out. Yes, Air Pleasure, you want to withdraw what?
Lordship, on the last occasion, your Lordship had asked a question in regards to whether the shutter was existing. The shutter was actually existing. We did not build it. It was there from the beginning. The problem is along with the no pilot. No, it was demolished, my lord.
You did not build the shutter.
No, I did not build it, my lord. My only difficulty is
The
along with
shutter
the
was built by the private respondents.
private respondent, my lord.
As
I
per
agree.
you.
Yes, my lord.
Very well. it has been demolished by the GMC.
Yes, my lord.
The private respondent is not here as a writ petitioner.
Oh, my lord.
If you have finding any difficulties, you can very well take resort to your lease deed against the private respondents. So this court has no business.
I bow down. May I just say one thing, my lord? Just one thing. The shutter that was demolished, my lord, along with the shutter, they demolished certain walls. Now, that I'm saying has created a concern to me. And I have been operating like this. All I'm saying, my lord, because there's a suit being filed.
Therefore, the question is,
Yes, my
you
lord.
need to take it up with the
Concerned authorities.
lessor.
My lord, the lessor is not doing that. 2-3 letters we
So
have
if the
written, they have not
lessor does
responded.
not do, Mr. Fukon, it is not for this court to give you an advice what to do.
I agree. I completely agree. May I only say this much? If let me at least go to the authorities and say, in regards to the demolition of the walls, if they want it, if they don't give me the permission, is fine. Only that
First of
liberty.
all, do you have a right to construct?
My lord,
My question is this. If
the
you are
walls.
in difficulty, no, Mr. Counsel, you have to see. If there is a difficulty out there, there is an application. This will be again advising you, which I don't think is permissible, but whatever it may be,
No.
you can very well ask for a mandatory injunction before the trial court
I'll-
and get an order for reconstruction. I still remember those cases pertaining to the fire out there in Fancy Bazaar, where orders were taken for the purpose of reconstruction.
Yes, my lord. Yes, my lord.
So
I
this
agree.
is how you do it, not
I-
here.
I leave that to your lordship. I leave that to your lordship.
What to do? Dismiss, withdraw, which one? Liberty. Heard Mr. R.B. Phukan, the learned senior counsel, assisted by Ms. D. Das, the learned counsel for the petitioner, Mr. S. Bora, the learned standing counsel of the GMC, as well as Mr. R. Sharma, who appears on behalf of the performer, respond numbers 5 to 29. The learned senior counsel appearing on behalf of the petitioner submits that he has been instructed to inform the court that the shutter, which was demolished by the GMC authorities, was not constructed by the petitioner. He, however, submitted that while demolishing the shutters, there were further certain RCC structures were also demolished. Thereby, it has become difficult on the part of the petitioner to carry on the business in such a carry on his business. Full. It is the opinion of this court that the dispute therefore lies between the petitioner and the private respondents. And under such circumstances, it is not, and as such, under such circumstances, the public law remedy, which is the remedy herein, cannot be invoked. In that view of the matter, this court is not inclined to entertain the instant writ petition for which the writ petition stands dismissed. Before parting with the record, this court makes it clear that the dismissal of the instant writ petition shall not prejudice or preclude the petitioner to avail remedies before the appropriate forum. It's advised. I think that is enough.
I'm extremely grateful for your lordship's kind consideration. I'm extremely grateful.
Actually, this land doesn't fall in the under Silchar Revenue Circle. It falls under Katigara Revenue Circle, Mala. Page 3 of our affidavit, ma'am.
Now, who appears for the PDCL? Yes, what is your stand? Here the case is the petitioner wants the shifting of the transformer to another location. Now, why you are not doing so?
The transformer was back in 2012. Land records at that time were not on that point of time. Now they're claiming that the public transformer is built upon their land. So for relocating, we have given them estimate budget that will be required for relocating that transformer.
So you are taking steps for relocating. You're taking steps for
We are
relocating.
agreeable to take for taking steps.
Not agreeable. Are you taking steps for relocating? There's a difference between both.
My lord, yes, we are taking steps for.
So give an update on the next day. Mr. So-and-so, who appears on behalf of the respondent, APDCL, submits that steps are being taken for relocating of the public transformer from the petitioner's land to a nearby location. He therefore submits that some more time is required to give further instructions. Taking into account the above, list this matter on 7th of October 2026 for an update.
Obligement.
In this case, my lord, on last occasion, my lord, who directed Mr. Sharma to file an affidavit. The affidavit has not yet been filed.
Your lordship, we will file the affidavit on after next 2 weeks.
Huh?
After 2 weeks, we will file the affidavit.
Why haven't you filed the affidavit? Notice was issued on 9/1/2025.
Yes.
We are in 2026.
Actually, there are
When?
some delays from the department itself.
I'm not concerned with that, whether the department has delayed or not. That is your lookout. If you are not in a position to control yourself, well, let's call this, who is the AFDC? Let's call the AFDC Director, Managing Director tomorrow,
Actually,
Monday.
it-
File your affidavit by Friday, next Friday, else we take it up. Produce the records on the next date.
Okay.
The record reveals that a notice was issued by this court on 9/1/2025. However, the respondent who has filed the affidavit, however, the
AFDC is to file.
have not chosen to file their reply affidavit in opposition. Full stop. It is also seen that time have been sought for on behalf of the AFDC to file the affidavit on 10/2/2025 and 16/6/2026. So considering the above, a final opportunity is granted to the AFDC to bring on record their stand by filing the affidavit on or before 12th of August 2026. List is Mr. B. Rahman, the learned counsel appearing on behalf of the petitioner, submits that on one hand that the petitioner's settlement was terminated, and further, the respondents have already imposed an amount of rupees 88,69,314. Full stop. And therefore expresses urgency in the matter. Full stop. Considering the above, this court fixes this matter on 27/8/2026 at 2 p.m. for final disposal. So it is observed that if the respondents AFDC fails to file the affidavit, on or before the date fixed herein above, the records be produced on the next date, and the instant writ petition shall be decided on the basis of the materials which is available on record. So it is observed that if the records are not produced, this court shall presume, not only presume, shall not only draw adverse presumption, but also may pass appropriate directions against the erring officials. Mr. Sharma, either file affidavit or produce records, because that day some department did not produce the records, neither appeared. I have imposed cost at 30,000 and then asked them to get it to the Bakijai officer. Be careful. I'm not on that today. Get your records on that date. And if you don't,
কোনখন আকৌ ফাইল কৰিছে নেকি না আৰু এটা কথা আছে
yes, why haven't you handed over the land?
Sure, there was an encroachment over that particular plot of land, Your Lordship. That encroachment has been removed only on 30th of June, Your Lordship. I had
Then, now you are going to hand over.
Lordship, that affidavit was filed. Page
My
23.
question, madam, my question is this. Petitioner have been allotted a plot of land. Yes or no? Yes. 82 bighas.
yes
That's what, Your Lordship.
What is this? What petitioner is this? Why it was been granted?
NGO, Your Lordship.
it's an NGO, my lord.
For what? Why so much land? Given
Lord, there are not many members, my lord. They will undertake dairy and all these activities.
Let's see the allotment order.
Yes.
82 bighas is a huge land.
My lord, page 26 is the district level advisory committee's thing at page 26.
The House has advised to communicate with the government regarding proposal of allotment of 82 bighas covered by DAG number 106 of AR Reserve. The under so-and-so in the name of so-and-so as there is a ban of allotment of reserve land.
VGR land, Your Lordship.
Huh?
The VGR land.
This is a VGR land.
Yes.
You are allotting to them.
No, Your Lordship.
No, now, my lord, there are,
Not now. Prior, it was.
no, my lord, the allotment was subject to de-reservation.
Hmm.
Apparently, my lord, de-reservation was not done. So far, so good, my lord. Then the stand taken earlier was these lands were being encroached by some people. That is also correct. At that point of time, because of two reasons, my lord. One, de-reservation was not done and it was encroached. Now, subsequently, land has been cleared from encroachment. Now, my lord, the local MLA has taken over the land, my lord.
It's okay, but my question
No,
is, has it been de-reserved?
No,
No,
till
Your
that
Lordship,
not.
it is.
No, if on account of de-reservation, it cannot be.
How are you granting reserve land? As per the land policy of 2019, you cannot grant the allotment.
Lordship may kindly take the affidavit.
If your lordships will kindly come to page 44, my lord, that is the conditional order, government order, my lord.
Inviting
With reference to your letter on the subject stated above, I am directed to say that the governor of Assam is pleased to order for de-reservation and then for allotment of VGR land measuring 82 bighas, so and so, so and so, so and so, in
Wait,
favor of Borkhetri Trinamool Hikkhito Nibunua Jubo Samas, subject to utilization of the land gainfully. So it was not done, my lord. Let us be very clear about it.
is to order for de-reservation of the then and then allotment of VGR land. So unless de-reservation is not granted,
Cannot be given.
Yeah.
That I cannot say no.
now
to that.
what are you asking for?
Now, actually, my lord, we want de-reservation and land should be given to us.
Huh. Now,
what instead they say, my lord, in our case, they say it cannot be de-reserved because of the Supreme Court judgment. Now, my lord, this entire land has been, boundary wall has been constructed, my lord, that we have given all these photographs and all. It was,
but this is not your prayer.
my lord.
Your prayer is not for de-reservation, to
No,
hand over the
no, my
peaceful
lord.
possession.
No, my lord, I cannot go against the condition of the allotment.
No, so-
My prayer is to give me the land. But then, my lord, to fructify the allotment, there has to be de-reservation. So without that, I cannot say.
Only the de-reservation will also require the reservation of same quantity
Same
of land
land
somewhere
for,
else,
yes, that is them.
which is a very difficult thing.
Yes, Your Lordship.
No, my lord, now what has happened? Now they want to close the door for us and the local MLA wants to take the land. The boundary wall has been constructed, entire area, my lord. We have given photographs. Kindly have a look at our affidavit, my lord. Copies of photographs, yes. If your lordship would kindly come to page 65 onwards, my lord. Kindly see. These are the photographs. Boundary wall has been constructed.
Okay, then
And in affidavit, they are taking so many stands. On the other hand, my lord, a land which is a grazing reserve, my lord, without de-reservation, these activities are going on. Page 65 to 72. If we cannot get the land on account of de-reservation, my lord, then somebody else also cannot get it.
Lordship, I have placed the current status, Your Lordship. This is the latest status, Your Lordship.
so it is here. So
There is no boundary wall.
What is that?
so it is vacant.
Yes.
So it is covered by fencing.
Yes.
Earlier there was no fencing. Recently it was done, my lord.
You have to, otherwise people enter.
No, there is no difficulty, my lord. No, my lord, if your lordship would kindly come to page number 79, my lord, the last affidavit which they file, if your lordship would kindly come to paragraph 8 at page 79. Page 79, para 8. This was the last written thing they have given, my lord. The opponent begs to state that in the light of the facts delineated above and the circumstances as prevalent as on the date as enumerated above, it is humbly submitted that Honorable Court may be pleased to allow the Revenue Department to call for a report from the Deputy Commissioner Nalbari, the detailed report and present status of land to enable to make a realistic assessment of the whole gamut of the issues involved. So this was their last pleading, my lord.
Lordship, I have submitted the updated status regarding this paragraph, Your Lordship.
Eight and 9. So basically they are praying for 8 weeks time.
No, there are two things.
Yes.
Madam. One is de-reservation. De-reservation means you have to have a corresponding 82 because of reservation in some other land. That is one. Secondly, you are taking the plea that the land which remains as a VGR cannot be given to the petitioners because it is a VGR in view of Jaspal saying you do not want to, you cannot give it. That is another aspect. But his allotment is a conditional allotment that you will de-reserve. My question is, now you have stated in that affidavit itself that the question of de-reservation is pending before the authorities. It has now been placed before the cabinet or authorities to that effect. So that needs to be looked into.
Cabinet has been formed recently, Your Lordship.
Huh?
The cabinet was formed recently on Your Lordship.
When?
Cabinet was just formed after the new government. Your
Come
Lordship.
to Assam very first time, huh?
No, Your Lordship, very recently after the new government, Your Lordship. So
No. Why I'm saying it, kindly see your affidavit. Kindly see the affidavit at paragraph number 6, Roman 2, paragraph of 6, Roman 2.
Paragraph 7, Roman 2.
The
Your Lordship.
dereservation proceedings followed by allotment settlement in all such cases are placed before the competent authority in the government and approved by the cabinet.
Yes.
Have you not mentioned that? So therefore, what is the status of the dereservation proceedings? Yes, because their allotment is subject to dereservation. If you don't dereserve, you cannot allot.
Yes.
You cannot allot as a VZR because that goes against the allotment letter. So therefore, what do you want to do?
Lordship, I'll seek
It's
instructions.
very clear. It has to be clear. But in the meanwhile, don't allot it to anybody
Exactly.
else other than which is permissible.
That instruction has been.
Don't allot to anybody else.
That instruction has been communicated. Your Lordship.
There is a stay order not to allot to anybody.
No, my lord.
Interim order is there.
No?
The order of status quo passed earlier. There is a status quo order is there.
Yes.
Order is there, Your Lordship.
Status quo as
Yes.
regards allotment, we make
Yes.
it clear.
That is.
Because if we pass a blank status quo order, it will impact many other things.
Many other activities.
Heard the petitioner, which is an NGO, was allotted a plot of land measuring 82 bighas. Subject to the same said land being de-reserved.
Page 41. my lord. Sorry, 44.
9th of October
Subject to
2002.
the said land being de-reserved.
Hmm.
First, it is seen from the records that the land which was allotted, that is dark number 106 at village Hakni Kandi or Hakni Kusi or what?
Bari Kusi. Bakri Kusi.
Bakri Kusi.
No, Bakri.
Bakari Kuchi. Bakari Kuchi. village.
Bakani Kuchi, Vijaya.
Bakri, Bakri.
Was earlier under encroachment. In the meantime, the encroachment have been removed. And the said land is presently vacant with effect from 1/7/2026, 5/17. As could be seen from the instruction placed by Ms. So-and-so, Standing Counsel of the Revenue Department. The said instruction is kept on record and marked with the letter X. Full stop. It is also mentioned that for the purpose of de-reservation, certain formalities are there which has to be approved by the competent authority. Full stop. Accordingly, this court fixes this matter on 16th of September 2026 for an update as regards the steps taken for de-reservation. As per the provisions of law. This court further observes, this court, taking into account the above directions, is of the opinion that the interim order which was passed earlier on 11/2/2026, the needs to be modified in as much as a blanket status quo order would also impact on steps being taken for the purpose of de-reservation. Accordingly, this court modifies the interim order passed on 11/2/2026 by observing that a status quo order shall only apply as regards allotment.
May I please? Lord, so far as petition, I am for the item number 34, my lord. But the petitioner, learned counsel for the, my lord, item number 33, he came to court, my lord, but he has to make an early exit on account of his personal difficulty, my lord. He told me that he could not remain in the court,
Oh, so we want an adjournment.
my lord.
Yes, I have the record. I need the same order in the, as is in the 31. I will produce the affidavit. 35.
Which one?
This one. That I will produce, I will file the affidavit and.
Affidavit is to be filed in respect of 34, my lord, item number 34.
The record is there, Lordship, but I need the same order. I will leave.
What, you want to file an affidavit?
Yes, Lordship, but. And
Okay, Mr. P. Sharma, the learned standing counsel of the AFDC,
AFDC, Lordship.
submits that the AFDC would like to file an affidavit. It is noticed that on various occasions, time have been taken by the respondent authorities for filing the affidavit, but no affidavit has been filed. Under such circumstances, a final opportunity is granted to the Fishery Department, AFDC, to bring on record their stand by filing the affidavit. List this matter on 28th of August 2026.
My lord,
The interim order which was passed in WPC number 407/2026 shall continue till the next date.
when I was there, my lord, so
For
for my lord, implement of a party, my lord.
whom do you want to implead?
Because, my lord, the president of the marketing managing committee, my lord.
Why?
Because he, under the, my lord, the allotment letter issued to us, my lord, that we entered into the land. Therefore, this court, while, my lord, deliberating the matter,
Whom do you want to implead?
the president of the marketing managing committee, my lord.
What is that?
Because the petitioners are the shopkeepers, my lord. So I want to implement him as a party respondent number 10, my lord.
Where have you mentioned properly his address?
My lord, it is there in paragraph 3, my lord,
Where?
of my interlocutory application.
Where?
Paragraph 3, number 11, my lord. That during deliberation of the matter, having seen that the sources of applicants locus standi rested on the agreement dated so and so entered into between the Assam Fishery Development Corporation Limited, that is the opposite party number
My
4.
question is here, where have you properly mentioned the address?
Address, my lord.
In the opposite party where it is there, you should have mentioned him. He has to be a part of it.
My lord.
That is why you don't mention the petitioner and the respondents. You say applicant and the opposite party. Then we say that the opposite party number so and so is impleaded as a respondent in so and so. This type of application cannot be allowed. File a proper application.
Right.
Mr. So and so, the learned counsel appearing on behalf of the applicant, submits that as there is a formal defect in the instant application, he may be permitted to withdraw the instant application and file a fresh one. Taking into account the above, the instant application stands closed on withdrawal. Limit is given to the petitioner to file a fresh one. Applicant. What is the matter about?
It's a matter about contract, and contract was taken by the petitioner, but the same was, SNIT was cancelled without any notification. And the finance department last time was directed to file their reply.
Oh, this one. Okay. Shall you have filed the affidavit? Finance is in your favor against you. finance has said something against you, it is permissible. They want these type of things to be carried out. Okay, where are you? On account of the paucity of time, the matter could not be taken up for final disposal. List this matter on 28/2026 at 2 p.m. for final disposal.
The affidavit filed by the finance man call to the court. That we have filed today.
The affidavit so filed by the finance department be called for records. Be brought on record by the registrar. Yes, what is this, Mr. Goswami?
My lord, it
Oh,
is
for that matter.
that matter, my lord. Initially, it was allowed, then it was rolled back, my lord.
Okay, this will take some time.
My lord.
We take it up on some other date. We fix it for hearing. All affidavits complete.
Yes, yes, pleadings.
All pleadings are complete. Accordingly, list this matter on 24th of September 2026 at 2 p.m. for final disposal.
Much of that.
Where's the again? Wish to make payment to you, Mr. DGP. Instructions?
My lord, I have sought for instruction, it is awaited, my lord. I
Why?
want to communicate.
DGP, na?
Yes, my lord. Home Department, my lord, I have sent. Let it be after 2 weeks, my lord.
No, no, no. These type of matters cannot escape this court.
No, to my lord.
Who is to make the payment? Who hired the vehicles?
DC, my lord. DC, my lord.
DC,
Then verify and my lord, they will pay.
district magistrate come district commissioner.
Yes.
Isn't it?
Yes.
Hello. And why are you making the DGP a party?
Because the vehicle was taken by the police and thereafter the vehicle was taken by the police. And thereafter it was handed over to the DC.
Now what happened to the vehicle
Order-
now?
Vehicle was used by the
Has
different.
the vehicle
departments.
returned to you?
The vehicle was returned, but vehicle was used by the CRPF.
By the
CRPF. E20 Battalion CRPF.
CRPF
Yes, madam.
on behalf of the DC.
On DC, madam.
Okay.
Lordship will grant us some time. We will clarify everything, my lord. We have got a communication also recently. They have sought for instruction from all the authorities, my lord, district authorities and all. I'll place the clear picture, my lord, and proper.
This is a
authority will be
matter of
done.
2025.
I understand, my lord.
Way old.
But, my lord,
Non-payment of
on the
dues
last
cannot
occasion, I
go
was
for.
directed to have instruction. On the last occasion, I was directed to have instruction, my lord.
And you did not obtain the instruction.
I have already communicated. I've got a response.
Understood, but if this is the state of an AG, then I think it is, I think the government advocates are much better
No, I have
better
communicated.
suited.
Well,
an
4 5
AG.
authorities are there, my lord. They have communicated.
Mr. Gogoi, the learned AG prays for some time to enable him to obtain necessary instruction. And the AG cannot obtain instruction. That day I passed an order for government advocates not being given. The district commissioner is not providing instruction. Now, should I pass an order that the AG also is not being given? Now,
it
tell
is-
me,
No, they have sought for time. now.
we get
I've
the
got a
instruction
communication.
next week. The instructions as sought for in the instant proceedings be placed before this court without fail on 31st of July. This will be no? 31st of July 2026, failing which this court would be constrained to seek the personal appearance of the person concerned responsible for withholding the instructions.
But it's that holiday listing matter, Your Lordship said, heard it on many occasions.
What to do?
Our
Matter
prayer,
needs to be taken up for final disposal today. When should we take it? This is for the earlier period, no?
yes.
Post you have taken
Post
care
we
of. Earlier period, it should be blacklisted or not. because that otherwise remains
As a
for
stigma.
future. So taking into account the pleadings are complete in the instant proceedings. However, on account of the paucity of time, the matter could not be taken up. Under such circumstances, list this matter on 25th of August 2026, 2 p.m., on which date an attempt shall be made to dispose of the petition.
Obliged.
Lord, I have received the instruction today itself. I have received the instruction today itself. I'll put it to an affidavit sometime in.
Mr. Endas, you also want to file affidavit? Counsels who represents the respondents seeks for a final opportunity to file their response to the allegations made in the writ petition. Accordingly, a final opportunity is granted by 9th, granted thereby granted to file their responses on or before 9th of September 2026. List this matter again on 18th of September 2026. It is observed that if the opportunity so granted is not taken, this court shall proceed with the disposal of the instant writ petition on the basis of the materials on record. Further to that, in the circumstance, the present proceedings cannot be proceeded in view of not filing the response by the respondent authorities, by the concerned respondent authorities. This court shall pass appropriate directions against the concerned respondent authorities for their seeking their personal appearance on account of the delay caused to the disposal of the present proceedings, which would affect as it affects the administration of justice.
Lordship, I have filed affidavit. There is some audit objection from the Accountant General, Your Lordship. Lordship, we have already given the letter to the Accountant General clarifying their queries, Your Lordship, on 7/3/2026, Your Lordship.
What is the audit objection?
Lordship, audit objection.
Huh? This one, paragraph 8 of the affidavit filed by the Brahmaputra board.
Yes, yes, it was.
Okay. From a perusal of the affidavit filed by the respondent number 4, it is seen that the total value of the work order was 24,13,204, and out of which the petitioner have already been paid 20,86,375. However, the remaining amount could not be paid on account of an audit objection by the Office of the Accountant General. This court also takes note of the affidavit filed by the respondent numbers 1 and 2, wherein it is categorically mentioned that in respect to the particular scheme, there is an audit objection to the tune of rupees 19.55 lakhs, and the Water Resource Department of the Government of Assam was directed to provide reply to that. Considering the above, an update be placed by the Chief Engineer, Water Resource Department, as to what further steps have been taken for the purpose of clearance of the auditory objection, and as to whether the Office of the Accountant General have rejected such replies. List this matter on 11th of September 2026 for an update. What is it? Oh, state freight subsidy. You have not filed affidavit.
No, my lord, it's awaited, my lord. Can it be after, my lord, 3 weeks?
What?
2 or 3 weeks, my lord. That is. Entire series, my lord, it has been rejected. So definitely, my lord, grounds will be there in this case, I suppose. Yeah, we have to do my lord.
Notice was issued in 2025.
No, it has been communicated. But today, my lord, some difficulty. I have come up with only one file I could get.
I think you should get it high time, you are a busy counsel, you should be getting your iPad.
Yes.
Put all these files in liquid text.
My lord.
Do the matters instead of going for the file, losing it out there in the waterlogging. Isn't it?
Lord, sir.
I would have understood the other councils may not be able to do it because the government of Assam is not affording iPad. At least the government of Assam can afford an to the AAG.
I have one.
Unless the plight of Mr. K. Gogoi is looked into. But in the high time, I think for you, particularly you, taking into account so many other matters, you need to put it out there. That day I was watching out there in the Delhi High Court, services being affected by airdrop. Because every lawyer uses liquid text in their iPads. So the service is affected. So I think we need to do something to the effect. Anyways. Court duly takes note of the notice was issued in the present batch of writ petition as far back as in the month of December 2025.
For the summer of 2026, from item
What?
44, it is 2026.
Which one?
matters. From item number 44 to my lord, 50.
This item is on December
Yes,
2020.
41 to 43, it is 2025.
It's okay.
Yes.
And in the Mr. B. Gogoi, the learned counsel who appears on behalf of the Industries and Commerce Department of the Government of Assam submits that the said department that in view of the taking into account that the present batch of repetitions would require specific affidavits to be filed in each case. Because there cannot be one. Everybody will have a different claim.
Different claim rates.
Comma. Some more time is required. Mr. A.K. Datta, you want to file affidavit? Mr. A.K. Datta, the learned CGC submits that although the fund is being provided by the union, but it is dependent upon the evaluation to be carried out by the state departments. Taking into, and as such, the union would not like to file any affidavit. List this matter again, this batch of petitions again on 7th of October 2026. In the meantime, the affidavits be filed on or before 28th of September 2026. Okay?
My lord.
And no more adjournments.
Lordship, there are 5 other read petitions of the same series which are not listed.
Give the number.
I'll give the number that may be
List
listed.
these matters along with so and so.
Much obliged.
Case, I need some further time to file my response, Lordship.
Huh?
I need some further time to file my response, Lordship.
Okay, what is the matter about?
My lord, regarding my lord, stopping of retail outlet dealership, my lord. Suddenly, my lord, the deputy commissioner stopped the release of products, my lord.
What is the impugned letter?
My lord, at page, my lord, 46, annexure 9, my lord.
What is this POL products means? What is POL?
Petroleum products, my lord.
And when did you set up the MS Star Fueling Center?
Yes, my lord. It is at Goraimari, my lord. At Goraimari area.
When?
In first commission started in the year 2014, my lord. Before, my lord, enactment of the act, my lord. At that time, my lord, the land was, my lord, agricultural land, my lord. Thereafter, my lord, the Assam agricultural land regulation of reclassification and transfer of non-agricultural purpose, my lord, act came into existence, my lord.
So you mean to say that you set up your petrol pump
Yes, my lord.
prior to the Assam Agricultural Land Regulation 2025,
Yes, my lord.
2015?
Yes, my lord.
When did you set up? 2014
Yes,
or
my lord.
2024?
No, my lord. My lord, first commission was started in the year 2014, my lord.
What? Where's your document here given?
Yes.
2014. Okay.
My lord, it was.
So you have set up your document prior to the act coming into
Yes,
force.
my lord, in the act itself, my lord, there is a provision
Okay.
in section 9, my lord. Deputy commissioner has the power.
So as you have not filed the affidavit for a long time, you make it until further orders.
Lordship, otherwise we have received instruction, but that is not sufficient. So I sought
Okay.
some clarification.
Because you have been granted, we cannot
Yes.
have it in time order till next
They
day.
also sought some time.
Okay.
Next day, Lordship.
Respondents, the state respondents have not filed the affidavit in opposition, and Mr. S.R. Borua appearing on behalf of the petitioner. Respondent numbers,
I'm for 2 and 3, Lordship.
respondent number 2 and 3 submits that a further opportunity may be granted. Revenue, Mr. S. Doctor, because you are the main person to file, not him. You are the person who have made this land, the act. It is not done under the aegis of the district commissioner. The act came into because of you. You are not going to file.
But the problem is that he has not served the extra copy.
What?
Not, provisions have.
Steps not taken.
Definitely department not served.
We vacate the interim order.
No, my lord, I think.
No. Now we got second file video. Step not taken, we immediately vacate the interim.
Not
Yes, sir.
Government advocate. Yes, steps taken.
maybe service copy.
What?
He is wanting to extra copy, my lord.
When was the writ petition filed?
Lord,
5/1/2026.
Yes, my lord. 5.
And order passed. No. Here it is received by Ms. G. Hazarika. You have a counsel named G. Hazarika? You're making a wrong submission. And you have put here unnecessarily to mental embarrassment. So we impose a cost on you. Mr. Fleho. Mr. So-and-so appears on behalf of the petitioner. Mr. S. Dotto appears on behalf of the respondent number 1. So-and-so appears for respondent number 2 and 3. And so-and-so appears for respondent number 4. No affidavit has been filed on behalf of the respondent numbers 1, 2, and 3. In spite of various opportunities being granted, a final opportunity is being sought for filing the affidavit. Considering the above, list this matter on 13th of November 2026. Interim or taking into account that the respondents have not shown, respondent numbers 1, 2, and 3 have not shown any urgency. And nothing has been pointed out as to why the interim order should not be continued until further orders. This court directs that the interim order which was passed by the learned on 7/1/2026 shall continue till the disposal of the writ petition.
May I please? My lord, as per last order 25/2022, they are supposed to file affidavit, my lord.
Affidavit.
Without work order, my
Pay
lord,
as
some-
per, verify 1 month, pay as
no,
per
without
comes.
work order, my lord, he has executed some work, my lord. Without any work order, he has executed some work. So that ascertainment will have to be there, man.
No, so you ascertain,
verify
why
the-
should I look into it?
Perfect.
1 month verification, pay as per terms rally, it will PWD order. Huh?
Oblige.
My lord, here, as per my instruction, my lord, the petitioner's claim is for an amount of rupees 7,03,083. As per my instruction, my lord, the total liability is only 5,44,350.
Where?
The various supply works were made by the petitioner. Different supply.
Who has to make the payment?
It will be by the PWD.
PWD.
Possible it is my instruction. Well, this instruction is in the first case, sir. In 52, I'm sorry, madam, it's 52. Lordship has directed us to verify. This is the exact amount.
I'm not on that. Yeah. This is nothing to do with this.
This is no nothing to do with this.
This is, say, you do one thing. This is a work for some legislative assembly.
My lord.
Who has the work, the verbal instructions of the
Will be, my lord, under the.
local member of the legislative assembly and the executive engineer, WR so-and-so, the petitioner repaired poor works. Very difficult, Mr. Counsel.
Apart from that, my lord, apart from
Apart
that,
from no, that is the
that work
work.
has been already regularized.
Copies,
There
photographs
tender
of the
notice has been
photographs.
issued.
This, so you go to the civil court.
No,
We
my lord,
can't-
I am not only that, my lord, and another prayer is, my lord, that work has been regularized. If your lordship can listen, annexure 4 series, page 26,
Wait,
page 26 onward. Those work has been regularized later on, but
Which
subsequently
did
we are
not.
not allowed to complete this work. That is another matter. And second matter is,
But where is your work order?
no, work order has not been given to me because I am the conductor here.
No, no, if the work order has not been given, what is this
Yes.
type of work you do and then this
No,
court
no,
is
then
going to
after
pass any order?
page 31, my lord, tender notice has been issued.
Tender notice has also been issued.
So yes, tender notice issued, but in tender notice, out of 4 items, 2 items not here. And against 2 items, I want to file, submit my tender. And I found that on only item number 28 and 29, page 36 has been here. Then I submitted my tender application against item number 28. But when I want to submit my tender notice, item number 29, they said that work is not there, it has been merged to another work. So item number 25, I already submitted my tender paper, my lord.
Verbal, civil court, not here. We can't look into this type of things.
Then your lordship will say
It's
one,
next to impossible.
my lord. Only one,
Mr. Ahmed, we go on the basis
my
of
lord, my lord,
admitted facts.
my lord. Now
Here
your lordship,
no, here is there a single statement showing that there is a work?
my lord, no, my lord, page 30 lordship will say, just a moment, page 30. I filed a
Is it-
representation, yes, my lord, page 30.
Yes.
That has been forwarded
Ah.
to the executive incentive, my lord, only they look under this, my lord.
No, how does it matter? You.
I'm wondering,
work-
I've been
When did you
forced,
do the work?
my lord.
When did you do the work?
I do the work, my lord, 2022-23 scheme, my lord.
And you got registration in 2025.
No to update, my lord.
Huh?
It is a renewed.
What renewed? You did the first time. Where is it renewed?
Annex 1 is also there. Annex 1, my lord. I am the old contractor, my lord.
So what?
It is renewed, my lord. Renewed, my lord. I am very old, my lord, contractor.
Very difficult, Mr. Counsel.
Annex 1 is my.
You are asking this court to prepare evidence for you. Isn't it, Mr. Gogoi?
Very reluctantly, my lord, the notice was issued in this case. The very-
Obviously, cannot be given.
Item
And
two-
why have you approached? When did you complete the work? No completion certificate, no
Nothing.
work order,
Nothing.
no acknowledgement, nothing.
Nothing, my lord.
Or Mr. J. Mohammed, the learned counsel appearing on behalf of the petitioner. Mr. B.
And
Gogoi.
I submitted my tender against item number 28. That will be.
Mr. B.
that will
Gogoi
say.
appears on behalf of the respondent numbers 4 and 5. Mr. 1, 4 and 5. Mr. S. Dutta appears on behalf of the respondent number 2. So and so appears for the respondent number 3. The petitioner herein has approached this court being aggrieved by the inaction on the part of the respondent authorities in making payment of the pending bill of the petitioner to the tune of rupees 9 lakhs on account of 4 works being carried out by the petitioner. This would have perused the materials on record. There is neither any work order issued nor any completion certificate issued. There is also no acknowledgement or admission that the petitioner had carried out any work. Under such circumstances, this is not a fit case wherein a writ can be issued for which the instant writ petition stands dismissed. Be that as it may, the dismissal of the instant petition shall not preclude the petitioner to approach the competent court of civil jurisdiction if so advised.
Hello.
Lordship, affidavit in opposition has been filed, my lord. I need to file reply, my lord.
What is this case?
Lordship, our name has been deleted from the voter list, my lord.
Have you approached and filed appropriate application under Form 5? No.
No, your lordship.
Then, no case. Go there. Where is that?
Section 23, your lordship.
Which form? Claim form?
Form 6, your lordship.
Go there. What is this? The council. No. The petitioners herein are aggrieved on the ground that their names have been removed from the voters list. So this court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner have applied in terms with Rule 23, rule or section?
Section 23.
Lordship,
Section 23 of the Representation of People's Act 1950.
in the final voter list, my lord, our name is there, my lord.
Then
And then, my lord, in the portal, our name is removed.
what portal?
In the voter service portal, my lord.
What
In
is
the
that
final,
portal?
after SR, my lord, in the final voter list, my lord, our name is included, my lord.
Your voters list name is there.
Yes, my lord. In the voter list, our name is there.
Well, what is this portal business? Portal means what?
Voter service portal, my lord.
Huh? What is this portal?
Maintained by
The online portal, Lordship. Lordship, they were not found in their address, Your Lordship. Lordship, Form 7 was filed against their inclusion. So a notice was issued. They were not found in their registered address. Lordship, the order for deletion was passed by the ERO, Your Lordship.
Then
Their names are deleted. They haven't approached the authority filing appeal under Section 24, Your Lordship. No appeal has been preferred
so
against
their
them,
names now have been struck off from the voters list.
Lordship.
See?
Yes, sir.
So therefore
But,
you
my
need
lord,
to
the-
file an appeal.
No notice was given and no opportunity of hearing, my lord.
Provision is there, na?
Sir.
Conduct of the, what do you call that? Preparation of the electoral rules. What is that provision? Conduct.
Lordship.
What
Rule
is the
21,
conduct of electoral rule, elections, one is the preparation of, yeah.
registration of electors.
Registration of, yeah. Relate, 1960 rules.
Lordship.
Yeah. Preparation. Correction of entries in the electoral rolls. Appeal. An appeal shall lie within such time and in such manner as may bear to the district magistrate or so and so. From any order of the ERO under section 22 or 23. Inclusion and deletion. Correction of net, if the registration of the is not considered on an application made to him or on his own motion shall draft and file it with the Okay. Where a notice was given?
Lordship, notice was given, but it could not be served, Your Lordship, because they could not be located in their registered address.
It is,
So did you paste the notice?
no, my lord, we are still in our address, my lord.
Did you paste the notice?
Lordship.
Because if you see Rule 26(3), there's a requirement of doing so. Where is the order for deletion of their name?
Lordship, it's annexed to my affidavit in opposition, page 40, Lordship.
You were evicted?
No, my lord, we are not evicted. My lord. No notice was given to me, my lord.
No, were you evicted from that land? Where are you residing on government lands?
Lordship, no, that instruction I have not, my lord.
Huh?
For my
Government-
instructions, they were residing in forest land. Forest land.
Forest land.
My lord, I need to take instruction, my lord, for that.
Oh, you got out in the SIR.
No, my lord, in the SIR, my lord, our name is included in the SIR, my lord. After SIR, my lord, final voter list was published, my lord, and our name is
So
included.
did you
in the-
vote this time?
Lordship?
Did you vote this time?
Yes, my lord. We are in the address, my lord, and we found in the address, and after
Did you vote this time? Voting?
no, my lord.
You could not.
No, my lord, I could not vote.
So was your names deleted before the elections or after the elections?
Before the election, my lord.
So you could not vote. Okay. So they say out there that you were, what were your addresses?
Addresses, my lord, Manikbond
Village
Punji.
Manikbond Punji,
Yes, my lord.
PO Manikbond.
Yeah.
All are residing in the same place.
Yes, my lord.
We do one thing, Mr. Counsel.
Sure.
We allow you to file appeal under 24.
Lordship, we filed, my lord, Annexure 3 may be seen, my lord.
What?
Annexure 3, my lord, may be seen. We filed, already filed, my lord.
Where?
Annexure 3, my lord.
No. This is not an appeal. We direct the appeal to be looked into, file an appeal under 24 against this deletion because you now have those orders which are there in the affidavit. And thereupon, we direct the district magistrate or these people to look into it and dispose it those appeals upon filing within 60 days.
Yes, ma'am.
Better off, huh? Because these are questions of facts which we need not, and allowing you to raise all the issues which are there in the present petition.
Yes, ma'am.
Okay? Better off. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent numbers 1, 2, 3, 4, and 5. The present petition has been filed by the petitioners, being aggrieved by the deletion of their names in the final electoral roll published on 10/2/2026 for the polling station number 211
Lordship, in the
under
final,
125.
our name is included, my lord, in the final.
So therefore, why didn't you vote?
Respondent not allowed to vote, my lord.
Now you say
Before election, we
directing
came
the
to the,
respondent to verify the electoral roll records with reference to the year. Well, your name has been deleted now.
now deleted, my lord. In the final voter list, our name is included, my lord, after SIR, my lord. I annexed the voter list also, my lord.
Lordship, the deletion order is dated 21st February. 21st February 2026.
After publishing, my lord, deletion was.
Being agreed, the present writ petition has been filed by 26 writ petitioners. Being agreed by the exclusion of their names from the voters list of polling station number 211 under 125 Patharkandi Legislative Assembly constituency in the district of Sribhumi, though their names were included in the final electoral roll dated 10/2/2026. This court duly takes note of that upon notice being issued by this court on 2/4/2026, an affidavit in opposition has been filed by the respondent numbers 1 to 5, wherein it is mentioned that certain objections were received what is BLO app,
Lordship, the booth level officer app.
wherein it was mentioned that on account of wherein it is mentioned that from the BLO booth level officer app, it was found that the petitioners were no longer ordinarily residing in the address recorded in the electoral roll and have permanently shifted. It was also mentioned that in pursuance thereto notices were issued, and as the petitioners were no longer ordinary resident as well as have not appeared pursuant to the said notice, their names were struck off. Their names were deleted from the electoral rolls. The orders against all the petitioners, which are all dated 21/2/2026, have been collectively enclosed to the affidavit in opposition and marked with the letter Annexure 1 series. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that not only the petitioners still continue to reside in the said address, but there was no notice even issued, which is the requirement of law in terms with Rule 26 of the Registration of Electors Rules 1960. He further submitted that the petitioner still maintains all documents which will show that the petitioners are resident are ordinarily resident of the locality in respect to where their electoral rolls have been prepared. This court have given an anxious consideration to the respective submission as well as the pleadings, and taking into account that there are questions which require a factual adjudication as to whether the petitioners are actually ordinary resident of the said land of the area, or the petitioners were evicted, as have been mentioned in the orders enclosed as Annexure 1 series to the affidavit in opposition. This court further takes note of that against an order passed under Section 22 of the Representation of People's Act 1950, an appeal lies to the district magistrate or the additional district magistrate or the executive magistrate or district collector or an officer of equivalent rank in terms with Section 24A of the Representation of People's Act 1950. This court further takes note of that Rule 27 of the Registration of Electors Rules 1960 stipulates as to how the appeal has to be filed and within what time such appeal is required to be filed. First, this court further takes note of that the petitioners claim to be unaware of the orders which are part of Annexure 1 series to the affidavit in opposition. And the petitioners are under a bona fide impression that this court would have bona fidely believed that this court would entertain the instant writ petition. And the petitioners have been bona fide litigating in the present proceedings. Considering the above, taking into account that there are various disputed questions of facts, this court is not inclined to entertain the instant writ petition. However, it is the opinion of this court that the non-entertaining of the instant writ petition should not prejudice the petitioners. Accordingly, the writ petition stands disposed of with the following observations and directions. The petitioners are granted liberty to file appeals before the district magistrate, Sri Bhumi.
District election officer. District election officer.
There is
That-
no district election officer
He is
here.
also the district commissioner, Your Lordship.
Obviously, but here it is mentioned as district magistrate. How can I say so? The file to the district magistrate oblique the district election officer oblique the district collector oblique the district commissioner of Sri Bhumi, na?
Lordship.
The district of Sri Bhumi. In terms with section 24 of the Representation of People's Act 1950, read with Rule 27 of the Registration of Electoral Rules 1960. The petitioner are granted 15 days from today to file the said appeal in the manner prescribed in Rule 27 of the Registration of Electoral Rules 1960. And if such an appeal is preferred, the said appeals be considered. Appeals are preferred, appeals be considered by the A Saita Namde Dilo oblique Sri Bhumi without insisting on the question of limitation. This court further directs the Saita Namde so and so to dispose of the said appeals if so preferred within a period of 60 days, preferably within a period of 60 days from the date of submission of such appeals. With the above, the writ petition stands disposed.
Most of it.
Editorial, the dismissal of the instant petition shall not prejudice the petitioner in those appeals.
Obliged.
We have filed affidavit lawsuit, any objection regarding lawsuit alternative remedy laws. Is covered by my lord judgment. Executive
Anyways.
same issue.
taking into account the paucity of time, the matter, no, so an affidavit in opposition has been filed by the respondents on 16/7/2026, wherein, amongst others, the maintainability of the writ petition has been put in question. Taking into account the above, list this matter on 19th of August 2026, on which the discourse shall hear as to on the preliminary objection taken as regards the maintainability of the writ petition.
Yeah, please.
Well, we have complied with the order 34/2026. New service connection has already been granted to this.
Here, ask for separate connection.
Yes.
Your Lordship, we have obtained the electricity connection, the matter may be disposed of.
Huh? What, tell again one more time clearly.
Your Lordship, we have obtained the electricity connection.
Oh, you have obtained. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petitioner has already obtained the electricity, has already been granted the electricity connection for which the writ petition has become infructuous. Mr. B. Chaudhary, the learned standing counsel of the PDCL, has also produced an instruction dated 11/6/2026 to that effect, to the same effect, which is kept on record and marked with the letter X. Taking into account the above, the writ petitions therefore stands closed.
My lord, my name, my lord B Das, my lord.
B Das, okay, sorry,
My lord.
B Das. Yes, what is this?
Matter related to settlement of fishery, my lord. Despite my lord, comparative statement prepared by the deputy commissioner, petitioner being the valid highest bidder, the process has already been sent to the government for settlement. Even after expiry 1 year, my lord, as yet no settlement has been made. Today, my lord, they have filed an affidavit by respondent number 1, my lord, have in opposition.
After the entitlement has been initiated. Why the settlement not granted? No idea.
No.
Okay. What do they say in the affidavit?
There is a Supreme Court order which they have not complied.
Oh, 18/3, 18/1/2002.
18/1/2018 by the deputy commissioner, so accordingly they are
So they are going for a fresh tender.
fresh tender.
Have they gone for a fresh tender?
As yet not done, as per information concerned.
Okay. Chalo. Let's list this matter again on 14th of August 2026. Taking into account that the affidavit filed by the Fishery Department, na?
Respondent number 1, my lord.
The respondent number 1, taking into account that the respondent number 1 have not filed have filed an affidavit in opposition, which is not on record. List this matter again on 12th of August 2026. Registry shall bring on record the said affidavit.
My lord. My lord.
What is this?
May I please, Lordship, Argo Council out of station, Lordship. Argo Council out of station, Lordship, can kindly consider it.
The mic, proper mic. Use the mic. Why you are going away from a mic? Yes, tell me.
Argo Council out of station, Lordship, kindly consider it.
Wait, let him say something. Well, what is he asking for?
My lord, they are asking for some payment.
Release of outstanding.
Yes, my lord.
Why you are not doing it, looking into
No.
it?
My lord, they have worked under 3 contractual works, my lord. One is Sobhagya.
File your affidavit.
My lord, I'll file my.
Mr. Bidas, the learned counsel appearing on behalf of the petition, the respondent, APDCL submits that some more opportunity must be granted to another opportunity be granted to the APDCL to file the affidavit in opposition was to list this matter on 18th of September 2026. The affidavit be filed in the on or before 14th of September 2026.
Oblet.
Here, my lord, I have got the parawise comment yesterday, my lord. I pay for 7 days time to file it. Regarding
Debarment?
debarment. Can file it in 7 days.
Taking into account that this is a petition challenging a debarment proceedings and there being no stay, comma, a final opportunity is granted to the respondents to bring on record their stand to by filing the affidavits. Mr. B. Gogoi, the learned standing counsel of the
Finance.
finance had done it.
Yes,
Debarment.
Yes, yes.
My goodness. Appearing on behalf of the finance department submits that the affidavit will be filed within 2 weeks. List this matter on 19th of August, matter on 24th of August 2026. Affidavit be filed on or before 14th of August 2026. Petitioner granted the liberty to file reply thereagainst. So an attempt shall be made to dispose of the writ petition on the next date. The petitioner also granted the liberty to mention the matter for upgrading.
I'm so obliged, my lord.
Only be granted some more time to file the affidavit. Because some criminal cases are pending, whereas charge sheet has been submitted. Granting of arm license.
We need some time, no? The state, Ms. Yudas appearing on behalf of the state seeks for 3 weeks' time for filing the affidavit. List this matter again on 9th of September 2026. In the meantime, the affidavit be filed on or before 7th of September 2026. Okay, that.
My lord, will kindly peruse the order dated 1/4/2026.
Oh.
My lord, there's an order, your lordship's order is there, 1/4/2026, paragraph 3, my lord. May I just read out?
Yes, first tell me, Mr. Borua, I have been always thinking of asking you, taking it to be a Friday, I'm asking you. Why your page is always different? Huh? What has happened? What is this
My lord,
matter?
there's an order dated 1/4/2020.
What matter? Why? What has happened?
What had happened, my lord? Petitioner number 1 and 2 had got relief. They've got the kist money, remaining kist money. Insofar the petitioner number 3 is concerned, my lord, there have been some developments which your lordship will find at page 103, my lord. Page 103,
We
the
do
last.
one thing, Madam, Mr. Borua, we do one thing.
My
Let me fix this matter on 29th with liberty to make on 29th at 2 p.m.
No, there's a matter in Shillong High Court. Can it be either on 28th or any other day, my lord?
Okay, 5th of August.
My lord, my lord, my lord.
Rejoinder not filed, na?
Perhaps not required, or I can file it, my lord.
You have been granted the liberty to file the rejoinder.
No, because the affidavit of the government makes it clear, my lord.
Okay.
Rejoinder is not required.
Mr. A.K. Borua, the learned counsel appearing on behalf of the petitioner submits that the petitioner is not inclined to file any rejoinder. So taking into account the above, list the matter on 5th of August 2026.
Obliged, man. DPO.
What is it?
May I please, your lordship?
These days,
Order dated 26/5, we have filed our
State
amendment.
Bank, unauthorized.
Yes, lordship. So amendment plead has been filed, lordship, and respondent number 7 and 8 has been impleaded, lordship.
What is the case?
Plus your fraudulent transaction, lordship. From
They
the
have
account of the.
implemented an unauthorized transaction took place in the said account and the total amount of rupees was shown to be withdrawn through such unauthorized. asserted that the said amount has been withdrawn by unknown miscreants. Okay, this is in terms with that type of matter.
Lordship,
which I-
they have implemented the
We have
Bharti Airtel
treated
matter.
Bharti Airtel
They
Lordship
have
as,
implemented the Bharti Airtel matter by amending the rate petition.
we have
matter.
amended
The
the
notice is yet to be issued
Yes.
to them.
to respondent
Same
number
problem.
Same
7
problem.
and
That
8. Lordship.
SMS was the delivered, the basic grievance.
Okay, notice have not been issued.
No, my lord.
They were implemented later on, Lordship, respondent number 7 and 8.
When he was doing notice, yeah. But, Mr. Madam, tell me one thing. Anyway, the I come the,
Yes, I is,
you have filed an amended writ petition.
yes, Lordship, that was filed on 26/5, as per order dated 26/5, amended plaint was filed, Lordship.
You have
Filed
filed the
in 6/1.
amended writ petition.
6/1.
Now you have allegations against Bharti Airtel.
Yes.
RTL, because my telephone, my ad,
No, it's
thing
okay.
is
I'm
registered.
not on that. I know that. But my question is, you're referring to which order?
Lordship, order dated 26/5/2025.
It is seen that though by that order dated
26.
when was he implemented?
Well, that implementing petition or that amendment petition was filed on 6/1 to
6/1.
So in the amendment petition, you have implemented.
Yes, Lordship.
It is seen that the instant application that pursuant to an order passed in 26/5/2025 in WPC number in IA number 382/2025. The writ petition was amended and the respondent number 7 and 8 were implemented. However, there is no notice issued upon the respondent number 7 and 8. Accordingly, this court issues notice upon the respondent number 7 and 8, making it returnable on 23rd of September 2026. The petitioner is directed to take steps by way of speed post by Monday. The respondent number 7 and 8, upon receipt of the said notice, shall bring on record their stand.
My lord.
I am appealing for the respondent 4 and 5 for the bank, my lord. We have filed our counter, my lord, already filed.
You are not going to file an additional
Already
count
filed, sir.
against the amended.
Oh, my lord. Same stand, my lord, only they implement that.
You also don't want to file. No, well, let us look
Yes,
into.
ma'am.
You have already filed, will
Yes.
not necessarily.
Yes, Lordship, the counter affidavit is not here because people, counter affidavit is not with me. I think because, Lordship, there was a change in council, so it's not there, Lordship.
These are all outside the court business.
Obliged.
Obliged.
70.
Great, your lordship. Lordship, rejoinder has been filed, lordship, but it is not bring to the honor court record, lordship.
What do they say? You are entitled to the amount.
No, one part depend, Mala, that maintainability question is there, Mala, but he is seeking against, order against GMC, but GMC is not implemented.
Huh?
GMC is not a party.
GMC is not a party.
Not a party.
Who is a party?
Officials of GMC are party, but GMC is not a party. Secondly, my lord, there are two type of order. One is the formal order, where the record has been seized by the chief minister within state. And other is informed, there is no order, viable order, he has supplied some labor.
Mr. Counsel, you have a lot of problem. Commissioner of Finance, is there anything? Is there a Commissioner of Finance, Mr. Counsel?
Lordship.
How can somebody help you out? There will be a commissioner and secretary to the government of Assam Finance Department. Where is the commissioner of finance? There is no person enjoying holding that post. Is he? And
Main GNC is not a party.
you have made the Swasthata officer, GMC.
Lordship.
Then you have made the commissioner of GMC. Then you have made the commissioner and secretary to the government of AR, GDD. Now, why are you asking that money for?
Lordship.
Why are you asking? that-
Lordship for desiltation, lordship work, desiltation work, lordship.
Oh, those word.
Yes, he has supplied, say that he supplied some labor, unskilled labor for decision exercise. And that is one part. Another is that oral instruction, say that there is a demand for orally, he has supplied another set of person.
Is one thing, you file your affidavit reply.
Reply, lordship, reply already filed, lordship, but
Not on record.
not on record, lordship.
They filed.
Okay, Mr. Counsel appearing on behalf of so and so submits that the affidavit in reply has been filed. Accordingly, the matter stands adjourned to be listed again on 26th of August 2026. In the meantime, the registry shall bring on record the said affidavit in reply.
Not affidavit has been filed. Only copy to the respondent number 4 could not be served by.
You got your affidavit?
Yes, Lordship.
Well, I have served it today, ma'am.
You are the owner of the land.
Yes, Lordship.
Huh? You are not the owner.
Sorry to say, Lordship, I'm just, I'm appearing on behalf of M. Soika. I don't know the exactly matter. Lordship.
Settlement has been given in the name of my lord, the daughter-in-law of the petitioner.
Who is the respond number 4? You are the respond number 4. Okay.
The real fact is that the respondent number, the real fact is that the respondent number 4 and her friends occupying a plot of land, one cannot find this. That was the
Gotland. Gotland, Sorkari Mati, Sorkari. And during the lifetime of the husband of the respondent number 4, they applied that plot of land under Bosundara scheme. And accordingly, the circle officer of Soigao Revenue Circle settled in favor of the respondent number 4 and her husband.
You have filed the affidavit.
No.
Why you are not filing that? Is it mentioned in your affidavit?
Yes,
List this matter again. It is seen that the
Yeah.
respondent number filed the affidavit in opposition. Accordingly, list this matter again. 7th of August 2026. 19th of August 2026. An opportunity, the respondent number being on record, they stand by filing their before 5th of August 2026. Petitioner also granted to file the reply on or before 13th of August 2026.
Much right.
Madam? Respondent number 4, we have admitted the amount manager.
Non-payment of outstanding dues of contractor, my lord. Affidavit was
From
filed.
whom?
Filed by my
Police department, my lord.
Please.
Yes, my lord.
Okay.
And
Where is the paragraph?
Page 6, my lord, affidavit in opposition. Page 68, my lord.
68.
Paragraph 6. Please. What's it disposed?
It is a lawsuit. But this matter relates to the tender, my lord. Happens to
This
allow-
name is the
No stand.
urgency.
My lord, can it be heard next week, my lord? If I-
Oh. Really passed an order there, huh?
Tender conditions are challenged after participating.
My lord, there has been apparent, my lord, hidden criteria adopted, my lord.
The tender condition or
My lord,
after participating in the bid. After participating in the bid, my lord, the tender conditions are now being challenged.
My lord,
The
that's not
financial bid
required.
is open.
That's not,
It cannot be.
my lord, if I may place, my lord.
Participating
Not granted it to anybody, nah.
in- The L1 is there, man. They are working.
Everybody has filed their
Filed.
affidavit.
Affidavit is on file.
Hey, August sucks. Taking into account that the pleadings are complete, list the matter on 10th of September 2026,
Lord, can I pray for August, my lord, one date?
not before this court. I can't do it. You want any other date, I can give it. Okay. The matters are here, the list the matter. Then when do you want?
My lord, first week of August, my lord, if not,
Of August?
I'm deeply obliged, my lord.
Baaki ko niligim. List the on account of paucity of time. It's the matter on 5th of August.
Deeply obliged.
List the matter on affidavit has been filed by the respondents. Gustav, is this matter again? But 2026. Very good.